my cupcakes. And thank you for choosing to spend part of your Monday, November 6th with me. Aren't you so proud of me? I learned how to do a poll. Somebody challenged me the other day. And then after the third time of me saying, no, I can't figure out how to do it, the person said, just Google it. And I was like, oh, duh. So, according to my poll, 73% of you watched the trial live today. Congratulations. And I tried. I really tried. I did watch most of it, but it started early and it ended late. And it was a little bit salty today, especially in the morning. And I can't believe the judge held his composure as well as he did. And some of the attorneys held their composure as well as they did, because if you're a passionate lawyer like I am, sometimes you take it personally and you get a little nutso. Um, so what do you want to cover? I kind of want to do the motion to dismiss the juror first. I kind of want to go backwards today. And I want to do that first, because if you haven't seen it, I don't want to give away any spoilers. So I kind of want to do that one first. So I think that's what we'll do. We'll go over the motion to dismiss juror number 1, because that was done at the end of the day today. And then I think we should go back and listen to the spanking that happened this morning in open court of Mr. Hunter. And then we'll watch a little bit of that. We'll do Corcoran's testimony. And depending on how much time you guys have or want to spend with me, we can go over the jury instructions. The jury instructions, to me, are the most important part of the case. They're the most important part of the trial. And the jurors were given copies of the jury instructions. What were they, like 68 pages? I think 68 pages. And so the hardest part of the trial is trying to get the jury to listen to the jury instructions, because they can get kind of boring when the judge drones on and on and on. And it just sometimes it puts you to sleep if you're watching it. And I'm looking at my notes here, and he did read all 68 pages, and it took about an hour and a half for him to read that. So we could put it on a little bit of high speed for that. But I think what we should do first is do the motion to dismiss juror number 1 first, because if you didn't see that, there's kind of like some twists and turns to it, which are interesting. So let's do that first. And if you have questions, always put them in the chat. Let's be classy in the chat. If you've been here before, you know that my moderators are amazing. They are policing the chat like nobody's business. It is a safe place for so many of my viewers who suffer from not only CRPS, but other chronic pain, diseases, and disorders that are difficult to diagnose. And so this is a very caring place to watch the stream. I did wear orange yesterday in honor of CRPS Awareness Day, or Chronic Pain Awareness Day, or a month, or whatever you guys told me it was. So I'm out of orange. That was it. I have one orange shirt, and you saw it yesterday. So yes, we are going to be respectful, kind, classy, cool. That's what we do here. For those of you who are new, I am Melanie Little. I come to you with 30 years of litigation experience in New York state and federal courts. I have pivoted since then to being a legal analyst, commentator, and, as my kids are very proud to say, a YouTuber. I only started this channel about 3 months ago, and we are growing into a very nice and very kind community. And I am not a cupcake. That's my logo right there. I am not a cupcake. The pink sign over there that you can't read says, "You cannot make everybody happy. You are not a cupcake." I'm not a cupcake. I'm not always going to make you happy. I'm going to tell you my opinions. My opinions will shift based on the case. So in addition to my 30 years of litigation experience, I am also a mother of 5 and a working actor when there are no strikes happening. Feels like these strikes are never going to end. And according to Matt Bond, thank you very much for the super chat, I am also a spiffy legal mumbo jumbo talkie dudette. That is what I do. And coincidentally, I thought this was funny because I thought about this the other day. Did anybody ever used to watch the TV show Bull with Michael Weatherly? Bull was a show about a guy who was a jury consultant, and every episode was a different trial. And it was all about picking the jury and how important the jury is. And they would have in their crazy offices that they had that were so technologically advanced, a mock jury, and they would hire people who were just like the jurors and have them watch the case on the closed circuit TV and decide the case. Well, that show is no longer, but the day the world shut down, I auditioned for that show. I was in an audition to play a lawyer on Bull, and I came out, and I think it was March 14th or whatever it was in New York City, and the world shut down. But it was with Michael Weatherly, who I love. Not as much as I love Kevin Costner, who you know, if you watched my Kevin Costner divorce series that I did, he had me at Tin Cup. So that's a little about me. I'd love to learn a little bit about you guys too, but that's for another day on a members only live stream. So let's take a look. We're going to go to the end of the day where the judge addressed the motion to dismiss juror number 1. We're going to talk about it because there's a lot to talk about there, in my opinion. Let me know that you can hear it. And I do stop the stream and talk about it. So if that's not your thing, you might not be happy, but I'm going to tell you now that's what I'm going to do. I'm not going to just let it play, because what's the point of you coming to watch me if I'm just going to let it play? You could have done that all day. It's probably maybe what you did. And I'm here to give you the legal expertise. So win-win. Here we go.
Okay. Members of the jury, in a moment, I'm going to let you retire to the deliberations room, but you are not to begin to deliberate anything, because we're going to have home just yet. But I am tomorrow and some further. We're going to have additional arguments tomorrow and some further jury instructions. You're not going to go home just yet, but I am going to be sending you back into the jury deliberation room. So do not discuss this case amongst yourselves. Do not do the investigation and receive no information. Now, I'm going to send 11 of you. I'm going to keep juror number 181 out here with us. Okay, so if the 11 of you can go back into the jury deliberation room.
All right.
This is so funny because I think I have this on 1 1/4. And it's on 1 1/4 right now. When I tried listening to it at normal speed, it felt like it was abnormally slow. So once you start listening to it on a higher speed, you just realize how slow he
speaks. The only
juror
that remains with us is juror number 181. All 11 other jurors are not with us. I did receive your note, and I have discussed it with the attorneys. I'm sorry that you're experiencing the issue that you put in your note. I don't want to say what it is. What I'm going to do is I'm going to discharge you from your further service of jury duty. I already have a juror note for you. There's a whole bunch of things I would like to say that I don't have time to go into, so I'm just going to kind of give you the short statements here. Number 1, I have already entered a court order prohibiting the disclosure of the names of the jurors until after the trial is over.
Okay, so in case you haven't caught on yet, this was kind of weird because we all thought that he was keeping this juror there because he wanted to question this juror as a result of the motion that was made by the defense to dismiss juror number 1 for bias because they didn't like the questions that he's been asking all along. But that's not what this is. This juror sent a note to the judge saying, "Judge, I have a medical issue. I need to leave." And so he's being excused, but his instructions to him are interesting. So we're going to listen to this.
You know the names of the jurors. So I'm telling you, until the trial is over and everything's done, you cannot let anyone know the name, identity, where they work. Do you understand that? Okay. You're going to be free of all other instructions. And so in a moment, I'll tell you what that means. But the bottom line is you're going to be free to talk about whatever you want. You're going to be free to look at whatever you want. You're going to be free not to talk about whatever you want. That's going to be totally up to you.
That was not me. That was the stream. So can you hear it better now? It just all of a sudden the audio went up. I wasn't watching it on this channel earlier today, so I didn't notice that. But hey, so since he's dismissing this juror and saying you can talk to whoever you want, if anybody knows who this juror is, have him call me. Wait, we can get him on the show.
But one of the most important things I need you to remember is until this is all over, you cannot say anything about the names of the other jurors. Unfortunately, because I'm going to be discharging you, I cannot have you say goodbye to the others. And I feel very sorry that I'm going to have to do that to you. What I will do is if you leave your telephone number with a court deputy, and if you are comfortable with it, when this is all over, I will give your telephone number to the other jurors. And then they can contact you and and I'll ask them to give me their numbers so that you all can communicate back and forth. But that's not going to happen until after this is all over. So it's totally up to you if you want to leave your telephone number for us to give to the other jurors. And again, I apologize that you're not going to get to talk or say goodbye to everybody else. You have given us over 9 weeks of your time and attention. You took copious notes. You asked lots of questions. You did everything we asked you to do as a citizen of the state of Florida. And I cannot tell you how much I appreciate it. I know you have a job, and I know your employer has given up your skills while you were with us. And so on behalf of all the lawyers in this case, and on behalf of the court, I want to say thank you. I do have a certificate. I didn't know this was going to happen, so I don't have the certificate ready, but I will send that to you as well. Also, if you leave us your cell phone number, when we have a verdict, my assistant will call you. If you want to come on down to watch, you can do that. If you want to sign online to the Zoom or tap into any of the number of feeds that are being broadcast, you will be able to do that. So with that, I'm going to go ahead and give you the formal discharge instruction. And I'm going to file this note, although Madam Clerk, he put his name on it, so the name has to remain protected. On behalf, and Juror 181, on behalf of the parties, lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. And I also wish to advise you of some very special privileges enjoyed by jurors. No juror, that would include you, can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that the jury's deliberations, discussions, and votes should remain their private affair so long as you wish. And I know you didn't deliberate, and I know you haven't been discussing the case, but I'm just reading you the instruction. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to approach you. They are not permitted to initiate any communication with you about the trial. However, you are free. If you wish to speak with any of the lawyers or anyone else about this trial, you may do that. Can't tell anybody the names of the other jurors until this is all over. So you have the right to refuse to speak with anyone, and you can also talk. It's going to be totally up to you. Please understand that a request may come from those who are simply curious or those who may seek to find fault with you. And it's going to be up to you to determine whether to preserve your privacy as a juror. So do you have anything in the back room? So
Did you leave any eggs back there? Maybe that would have been funny if he said that. That would have been really funny. He is a very kind judge. I find his demeanor to be very kind and measured. And anytime he feels like he's going to lose it, he says, I'm just going to go take 5 minutes. And he leaves and I think he does some deep breathing exercises and he resets and he comes back. He's never, listen, so many of the judges I dealt with during the course of my career were hot-headed. They would be screaming and yelling in the courtroom. Maybe it was a different time and not everything was recorded then, but you can't use your phone in the courtroom. You can't be recording things. And the judges a lot of judges are very, very short-tempered, loud, and yell a lot. Maybe that's just New York. I don't know. You guys can let me know if you practice law in another state, but he's very measured. Also, maybe because he knows there's cameras on him all the time. So he's maybe being extra special careful, but I do like him, you guys. I agree with you.
So you do not need to go back in there? Okay, so what I'm going to ask the sheriff's office to do is to take him out that door and take him directly to his vehicle and let me know when he is gone so we can then let the other jurors go, because I don't want there to be any possibility of them overlapping. So what I'm going to do is, and I'm going to ask the TV folks, as he goes through this other door, let's make sure we do not capture his face. Thank you very much for yours. I hope the medical issue resolves in a quick fashion for you.
So apparently he had a medical issue. He asked the judge to be excused. The judge did excuse him. I think we are all way too familiar with this thing on the top of the door. We see a lot of that during the day. So that was the little fake out. We thought that was going to be the juror in question, but it was not. So I'm gonna leave the closed captions on. Do you want me to leave the closed captions on? I'm just gonna say don't rely on them because they're not very reliable. So far they've been okay, but oftentimes they are just terrible.
Okay, thank you.
All right.
Okay, everyone can please be seated. Sorry, I didn't mean to do that. I just have to wait for another deputy to come so I can bring back the other 11. Why don't you bring them in?
Okay, so then they're going to talk a bit about jury instructions, and I'm going to fast forward to the portion where they, oh no, not jury instructions. They talk about something else where they take a break, but it doesn't, they talk about, oh, some corrections to the jury instructions, right? Because we're going backwards. He already gave the jury the instructions. He read them the instructions. Then they talk about some changes. And now we're going to go to the actual motion to dismiss juror number 1.
We have before us a motion for juror disqualification of juror number 1. That was filed by defense. I've read the motion. I've read the response. I'm happy to accept further argument. Hopefully it won't overlap too much what was started.
No, I'll be brief, Judge. I know that you read materials that have been provided to you. I do want to emphasize a couple of things and comment, if I could.
Sure.
I would say that I understand this is a very rare motion to bring. I've been practicing for almost 40 years, almost 200 trials, and never had to bring this kind of motion before. So I appreciate the gravity of it. I appreciate the unusualness of it, but we do believe that it's merited in this case.
Unusualness. I don't think that's a word. Unusualness, but I'm going to turn off the subtitles because they're annoying me. I don't know if you want to back on, tell me, but I find them kind of annoying, and I think the audio is pretty good right now. If you guys really need them, let me know, or you can turn them on your end, I think.
As you know, you're vested with the discretion in determining whether a juror has engaged in misconduct. By misconduct, in this case, we don't mean that he has listened to news or done none of that things, but what we're talking about is that a juror that we believe has violated the instruction to not form any definite or fixed opinions about the merits of the case until all the evidence is in and arguments of attorneys and instructed on the law. We believe that deciding a case before hearing all the evidence is the antithetical to a fair trial. And I know that Your Honor has we've pointed out some of the jury questions from this particular juror, but there are a couple I just want to emphasize. I don't have a page number, but this juror particularly in one of his questions started with, you and this juror are not psychiatrists, we are humans and have feelings, etc. But goes on to say, is it possible that Maya's waning abilities could all in part be contributed to what J Hatch was causing? The limiting of family interactions and the stress and trauma Maya's testified to, documented statements to Maya about her mother's status, told to Maya by hospital staff, Miss Beatty. Could all this possibly have affected Maya's participation in your therapy sessions? To me, to the defense, that is a clear indication that this juror has already determined what the evidence is on those issues.
Okay, so which one in your motion are you referring to? What little letter? 2A, B, C?
Oh, I don't know, Judge.
I'll
I'd have
start.
to go back and connect that. And I can do that if asked. The tenor of the questions that we've addressed in our motion and the specific questions that we reference clearly, in our view, show that this juror has predetermined the evidence.
Oh boy, not enough sticky notes on those papers. And
one.
really, I mean, to be fair, she
This
doesn't have, she hasn't had a lot to do.
This one specifically, Judge, I'm
During
sorry,
this
I don't know if
case.
it's A, B, or C, but the question specifically states, will the jury be able to observe Sally Smith as a live witness or by Zoom during these proceedings? And goes on to say, are we able to be told, as there appears to be probable cause of improper actions of Sally Smith in her assigned role at JHatch, was she written up or coached? Is Sally Smith still performing duties at JHatch? To me, that is a prime example of the concerns that we have with respect to this juror, since he's already determined that there's probable cause that Sally Smith did harm and did wrong.
Okay, well, we're going to find out later. And I had asked you guys this yesterday, if we thought that this juror number 1 was law enforcement or former law enforcement. It turns out that he is. So for him to use a phrase like probable cause is not unusual. And they know who he is because they picked him. So they know that he's law enforcement or retired law enforcement or former law enforcement, whatever he is. He's got a law enforcement background. And therefore, that question is not unusual. So, I mean, they can try and milk it as much as they want, but we'll see if they win.
To further
Even with the word may,
the word may,
Mm.
did you read that may be probable cause?
I don't think it did.
Appears to be.
She
probable
can't even find the thing she just read. So we're going to rewind it.
Did you read
Further
even with the word may?
determined that there's probable cause that Sally Smith did harm and did wrong. To further
Even with the word
prime example of Sally Smith in her assigned role at JHatch, was she written up or coached? Is Sally Smith still performing duties at JHatch? To me, that is a prime example of the concerns that we have with respect to this juror, since he's already determined that there's probable cause that Sally Smith did harm and did wrong. To further
even with the word may,
the word may,
did you read that may be probable cause?
I don't think it did.
Appears to be probable cause.
Well, again, Judge, though, it's a predetermination by this juror, his hostility towards the defense witnesses, his advising that he happens to be of the same ethnic background, and maybe we just thought she was pushy because of that. The fact that he considered one of the nurses a breath of fresh air because she's the first person to say anything nice about Maya. All of these, when you put them,
He didn't say because she was the only person to say something nice about Maya. Breath of fresh air could mean a lot of different things. It could mean finally you had a witness on here who wasn't snarky. It could mean a lot of different things. It's, her interpretation of what these questions meant is, way beyond the scope, if you ask me.
altogether, Judge, are a pattern and an indication and evidence that this juror has already decided the case without any deliberation with his other fellow jurors, without any instruction on the law. Suggestions that the witness has overreacted, indicating his view of the CRPS. I mean, the hostile questioning of Miss Laporte. Are you attesting to this juror that you were the only one on the call? I mean, the whole tenor of all of these questions that we pointed out in our motion indicate that this juror has made up his mind. And it wasn't even, I mean, it was from.
You can hear the judge going, No, I don't have a fancy sound deck where I can balance the sound. So I'm just going to try and talk a little more softly. And hopefully it'll balance out that way.
Pretty much after the Kowalskis testified. And from that point forward, I think the evidence shows he turned a deaf ear to the rest of the testimony, and that his questions indicate that. We think under the law that there is sufficient grounds here for this court to, in fact, change his status from being one of the jurors to one of the alternates. And that would be the appropriate to handle it. We think the Allberger case supports that. We don't think it's necessary to interview the juror. We think that when you look at Allberger,
Of course, we don't want you to interview the juror because we don't want you to give him an opportunity to say that he hasn't made up his mind yet and that he can be fair and impartial. We just want you to rule on our papers.
That the appellate court will support that you as a trial judge were here and could judge this matter as the trial judge. The Washington v. State case that the plaintiff cite to, which is first DCA, the tenor of those questions were not the same, Judge. The judge seemed to just be irritated because they were asking a lot of questions, but it wasn't that the questions were hostile or indicated that the juror had already made up his or her mind.
We spoke about this yesterday too. Depending on the tone of voice in which you read those questions, they can be taken as hostile, they can be taken as sarcastic, they can be taken as kind, they can be taken in a lot of different ways. So you cannot interpret tone from a written question that somebody put on a piece of paper. You just can't.
So we believe that this is the appropriate motion to bring, and it should be granted.
Now, my reading of the Alberger, and that's ALBERGER versus Harbison, HARVISON, 342 Southern 2nd, 537. There wasn't a discussion as to what the jurors' questions were. My recollection of that case was the trial judge had already determined, as a matter of fact, that the juror could not be unbiased and fair.
There's no detail in the, agree, there's no detail in the actual case as to what it was. It just said that the appellee's counsel voices objections on the grounds of the nature and manner of the juror's questions, and it was apparent the juror had shown bias and lack of objectivity. And then a juror was substituted over objection, that the juror was substituted.
Sure. So let's just interpret the case the way we want to and make up the facts. But the judge already read the case. He's like, that's not what it said. Okay.
And we think that that is the case we have here, Judge. I mean, when you look at the totality of these questions and the hostility of these questions, as we detailed in our motion, and I could point out some others, but I think the court has read the questions. Certainly during trial, the court read the questions. There were times during this trial when we at the bench pointed out, Judge, that seems to be a question where this juror has already made up his mind.
Let me ask you this. I mean, everyone knew that this juror was former law enforcement. I mean, we knew that from day one, given his jury questionnaire. And isn't it something that law enforcement officers do, is they confront people with conflicts in stories and evidence and see how they react? Isn't that just how a person digests information? And it's just, we knew he was former law enforcement, and therefore we could kind of expect that he was going to ask tough questions, sharp cross-examination type questions.
Well, Judge, I don't think these are tough cross-examination questions. I think these are questions that show a bias. They aren't objective questions. They are bias questions. When you talk about probable cause, when you talk about confronting a witness with, hey, wait a minute, maybe the reason Maya's having these issues is because of the fact that you separated her and you did this and you did that.
Yeah. Maybe that's why. Maybe.
Those aren't tough cross-examination questions. Those are questions that indicate a bias and that he's already determined that those facts are true.
Anything else, Ms. Cross, that you want to say?
If I can have a chance to respond to the plaintiff.
Sure. Who from the plaintiff is going to make the argument?
I will, Judge.
And you can tell me if I'm wrong, but she did not seem confident at all. At all. And we've seen her, attack. We've seen her on attack mode, and that wasn't it. So I don't know if she just didn't think her arguments were strong enough, if she's just rattled from what happened this morning, if she's been working all weekend. I don't know. She didn't seem as confident as we've seen her in the past. So just an observation.
It's interesting, the perspective, because I went back and looked at my notes from the first 2 weeks, and I had a big question mark next to Juror 1 as to whether he was dead set against our position based on the questions that he asked. He didn't say he had the same ethnic background. He said Nordic and a certain blunt way, I believe was his question. So he was not trying to identify himself, because she's from Poland, and I think he's talking about Sweden. And the breath of fresh air, he just said, period. He wasn't addressing that, and we don't know from that. What we're doing here is trying to go back and do another voir dire or redo voir dire. This this juror, like the court said, is probing every bit of this evidence and every one of these witnesses. And thank goodness there are jurors like that out there. So just because he has asked these type of questions does not disqualify him. If anything, he seems like a pretty contemplative juror, as do all of ours. So I don't, I mean, that having been said, I mean, we don't want an appellate issue, any more of the appellate issues than,
Well, let me just stop you right
go ahead.
Ms. Crowells is suggesting that juror number one status be changed from on the jury to being an alternate. So effectively not disqualify him, just shuffle the chairs. At the end of the day, do you agree doing that because you're concerned about it for whatever reason? Do you agree to do that or not? Because, you know, if you're going to agree to do that, we'll walk a certain path. If you're not agreeing to do that, we'll walk a different path.
The
Do you need a
alternate,
moment with Mr. Elegant and your team to decide that? Because when it's all said and done, if you're in agreement with Ms. Crowells on changing his chair from being on the jury to an alternate,
well, my one question, I want to confirm who takes his place, obviously, which I think is juror number 5.
Whoever
Who is-
whoever was the next.
my notes
I mean,
have.
we're not looking to shuffle the alternates, so whoever is the.
That's what I'm trying to figure out.
My notes have, and Madam Clerk, tell me if I'm wrong, that our jurors are jurors 1, 19, sorry, our jurors are 1, 17, 19, 93, 97, and 98. The first alternate is juror number 106, the retired electrician.
Yes,
Yes, Your Honor.
that's our understanding as well, Judge.
So that's the first alternate. You all need 5 minutes?
Yes, Judge, I mean, we realize what we're trading out, I guess. And we understand the position of the defense is they just want to trade spots.
We just want to, well, it's not unusual in a trial to sometimes make somebody that was a juror an alternate if they fell asleep during trial, if they had issues.
Oh, stop it. It's not unusual. It's like playing roulette, honey. It's like playing roulette. You better want what you wish for. Because you replace that juror with someone else, you might get somebody who has a much bigger checkbook. Or you might get somebody who is for the defense. You don't know what you're going to get. It's a risky move.
So that's our position.
I'm just wondering if there's an agreement obviating a ruling or is a need for a ruling. And I just, 5 minutes, let's keep this to 5 minutes because
Listen to that. I just want to.
do you want me to sit here and,
Yes, Judge. Let's.
well, if you need to call Mr. Elegant, though, you can step outside and call him.
You want me to sit here and twiddle my thumbs?
I'll just sit here and look pretty.
You had me a little bit nervous here, so let's see what happens. Still twiddling his thumbs. At least he's trying to be collaborative. He's trying to get them to consent so that he doesn't have to rule on it. So there's nothing to appeal.
I think I better stay with number 1. I don't
So
think.
you
we
were
have-
opposing the,
Yeah, I think I need to oppose that. I have very mixed feelings, but first, I think it's the right thing to do to keep him on there under the law and our system of choosing jurors. I don't see anything in his questions. I see him probing things deeply. And I think he, like I said, when we started out, I wasn't sure which side he's on, and I'm still not sure based on some of his questions.
I mean,
I think the point should be, he shouldn't be on anybody's side at this point, Judge. That's the point.
They all form opinions at some point and through it, and they're all cheering for one side or the other, and then they switch sides depending on the evidence. That's the nature of jury trials.
so I need your final answer, Mr. Anderson, so we can get this thing going.
You're a lot of help.
So someone has to make a decision for the plaintiff. So you are there. If not, I'll call Ms. Lawrence. She can give me the final answer.
You'd like to sub in Ms. Lawrence's durable.
We're not doing that, Mr. Whitney.
What was that old TV show, that game show? Was it Let's Make a Deal? Do you want what's behind curtain number 1 or curtain number 2, or do you want what's in the box?
No, I changed my mind. I'll go with number 5. So I'll agree with you.
Ms. Lawrence, is this your final answer?
It's not number 5, it's 106.
Well, hang on then.
It's the one he announced, the
I'm sorry,
electrician.
106, perspective 106. And
He's counting 1, 2, 3, 4, 5.
Yeah,
yeah,
yes.
That's
where
what
he's
you
sitting.
meant.
Okay.
Yeah.
All depends on how you count.
All right, so are we concluded?
She's like, hurry up, hurry up, hurry up, agree, stipulate, 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 consent, consent, consent.
Ms. Lawrence, is that your final answer?
Yeah,
Okay.
I think I'm gonna go with that.
Okay,
Okay.
so what we're going to do with
Swap
the
them.
agreement of the parties, and this is the agreement of the parties, is juror number 106 will move into the status of being on the jury, and juror number 1 will move into the status of being an alternate.
Which alternate? Is he just gonna swap with?
Is it going to
Does that
matter after tomorrow?
Probably not.
100% it could matter. If they're there for a week, somebody could have a family emergency, somebody could get sick, somebody could have a sick kid and have to leave. 100% it matters.
But
If someone has another medical emergency, we'll address it then, but
Yeah.
let's just pray no one has another medical emergency. How about that?
I hear you.
Let's
You know
not
what,
go about,
You know who I didn't check with through this whole thing? My client.
well, that would be important.
Okay.
Well, let's let Mr. Anderson talk to Mr. Kowalski.
Yeah, you might want to ask
Then can
Jack.
we move to exhibits, Judge, unless you
Well,
have.
let's give Mr. Altenberg another moment.
Yeah, I'm waiting.
Judge, Mr. Altman and I weren't able to talk, but I did send him a
Well,
text.
I'm gonna go with my client. I have to switch positions because my client feels more comfortable with juror number 1. So I'm gonna switch positions based on my client's input.
181 packet.
Did she just say what? Did she just say what? Who's doing jazz hands back there? Hold on a second. Yeah, that's what I thought. Did I just hear her say what? Okay. Yeah, I'm going to rewind that because we like to rewind the good parts.
Can we move to exhibits, Judge, unless you
Well,
have.
let's give Mr. Altenberg another moment.
Yeah, I'm waiting.
Judge, Mr. Altman and I weren't able to talk, but I did send him a
Well,
text.
I'm gonna go with my client. I have to switch positions because my client feels more comfortable with juror number 1. So I'm gonna switch positions based on my client's input.
181 packet. Okay, so your final answer, and just so I'm clear, the plaintiffs are objecting to the switch and wants, if I were to deny the change, your client wants the appellate issue.
So such as it is, I don't think there's much of one, but
Okay.
There was no misconduct on the part of that juror. Okay, jurors are removed for misconduct. Not for, if you're going to let the jurors ask questions, you're going to have to accept the questions the way they are phrased. The jurors do not leave their common sense at the door. They do not leave their occupation, their personal experience, their knowledge at the door when they come to sit on a jury. Your job as an attorney during voir dire is to weed out the jurors that you don't want, that you think will not be favorable to you, and that you think can be impartial. You have that opportunity during voir dire. The time for that is not at the end of the case when you decide that you don't think the questions are friendly to you. And this is what you get when you let jurors ask questions. We don't do that in New York. In New York, it's up to the attorneys to get the evidence out that they want and to do their cross-examination. It's kind of a slippery slope.
So the final answer is you're objecting.
I'm objecting.
Okay. Anything further, Ms. Crowells?
Judge, I think we've laid out the bias that we believe this jury has shown. I think that the appropriate ruling for the court is to grant the motion. I think under the case law, it's warranted. No, I have nothing further.
Court has before it the motion to disqualify juror number 1 for a question of bias. This is a very peculiar type of motion, and since normally when we see a question of juror misconduct, it's they've violated some sort of instruction of the court, like don't go to the accident scene, and they go to the accident scene, or something along those lines.
Or Becky Hill makes up some fake Facebook posts that your ex-husband might have made and accuses you of speaking out publicly about how you're going to vote against Alex Murdoch. So that's alleged juror misconduct. This is not misconduct. This is, I don't like these questions that are not favorable to my side based on the way that they're phrased. And another thing that I think, since we're on what I think, is if you're going to allow the jury to ask questions, the juror should not be identified. Get the questions, take the pieces of paper, shuffle them up, and read them anonymously. I don't like that they were outing this juror, because you know what? He's going to come back and he's going to watch this and he's going to know how they were talking about him. And that's not very nice. And now maybe this is going to prevent some people from wanting to go serve on jury duty in Florida, because they're going to say, oh, well, I don't want to be doxxed on every TV show and every YouTube channel out there. They didn't want me. They wanted to get me off. Jury duty is a really important thing that I think everyone should do. And this is another thing that this is shining a light on. After what's going on in the Murdoch case and what's potentially going on here, people are not going to want to serve if they're going to be doxxed and outed and publicly spoken about and publicly shamed like that egg lady. It's a problem.
The court has given instructions which the defense says that this juror has violated. For instance, instruction 202.2, you must avoid forming any final opinions. Keep an open mind. Actually, keep open mind is from 201.2. In this particular case, the evidence that the defense points to has to do with juror questions, and the court will, I think, without a doubt, everyone will agree that juror number 1 asked a substantial amount of questions. Now, to be fair, other jurors and alternates, although they don't know they're alternates, also asked a substantial number of questions. For instance, juror number 181, whom had the medical issue today, also asked a copious amount of questions. What we know about juror number 1 is he's a former law enforcement officer. We've known that since day 1. That's on his juror questionnaire. Everyone's known that. And certainly he survived the individual questioning, then the group questioning that we had for all of the jurors. During the course of this trial, I mean, obviously I said juror number 1 has been asking a lot of questions, and I don't know, maybe 3 or 4 weeks ago, the defense started referencing their concern about this particular juror. And certainly I've been paying attention both before, but acutely aware of each and every question that comes from juror number 1. The case law that's been cited to the court from the case for the defendants is the Allberger case.
Yeah, and your case law is kind of weak too, by the way. At least they didn't use ChatGPT to write their motion. Like those lawyers in New York, the ChatGPT lawyers who had ChatGPT write their briefs in federal court because they couldn't afford to pay for Westlaw, and the cases were all completely made up, and they got totally busted and shamed.
Case. And the best case, if you will, from the plaintiffs. I think it's, where did it go? It's the Washington v. State case, which is 955 Southern 2nd, 1165. Judge Padovano, writing for the first DCA, talks about witnesses who ask probing cross-examination questions, and how that is not necessarily any indication that the juror has violated an order or instruction of the court. The court's instructions, you can't form any final opinion, you have to keep an open mind. 9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case. Every single witness. Well, I don't think he asked that question today, but I think he asked a question on almost every single witness that wasn't by deposition. And the witness, even after the defense 3 or 4 weeks ago started pointing out what they were contending to be prejudgment, this juror continues to ask probing questions. If he had already made up his mind, why would he ask so many questions? If he had a final or fixed opinion, why would he continue to do this? Now, yes, he put a lot of prefaces into it, but I would say that his prefaces talk about context. And we have to remember that the jurors asked their questions after all of the lawyers. And perhaps this is bad on me, but I did not constrain the lawyers to a strict direct, cross, and redirect. I let them go for recross and redirect and recross until the lawyers were finished with their questions. That's just because I view this as a let's find the truth. And so I didn't want artificial boundaries on cross-examination and redirect to limit us. So the point is, sometimes it might be an hour and a half, 2 hours or so, or if we've taken lunch, even longer before the jurors were able to ask their question. And if they use, let's talk about this subject, and without providing context to the question, he might have written it down 2 hours before. So this juror was providing context. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case. On the contrary, I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location. And I've been watching the guy. And I have not only do I not have a doubt, I don't have a reasonable doubt, I have no doubt that this guy has not come up with any final or fixed opinion.
I've been watching you. I've been watching you, juror number one. I got my eyes on you. I've been watching that guy. That was the best part of his whole speech.
And when I reviewed the motion, the only thing that gave me any hint of an issue was the reference to the shared cultural sense of Beata Kowalski and this witness. And I went back and looked at the actual question that was asked, and I don't see anything in here where.
Yes, because in their motion papers, the defense attorneys did not actually quote the actual questions that were asked. They just sort of summarized them in a way that would best suit their argument. When they said, we couldn't find the exact question, we told them to go back and look on YouTube, but apparently they don't know that we're all talking about it. And Recovery Addict has most of their sidebars. So if they wanted to find the exact wording of the questions, even if they weren't asked, they could have.
Where this witness suggests even remotely that he is going to vote for the Kowalskis because of that, or vote against the Kowalskis for that. To me, it's just context. He was providing a situation of how he was framing the question. And then I go back to, this is a person with law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Now, there was a reference in the motion to, is he communicating? Obviously, there's no communication in the jury room every single break, even if it's for 2 minutes. I ask if they've been talking with each other, and the answer is no. So I have no concern that there's any hint of deliberations or discussions amongst the jurors back in the deliberation rooms outside of the court's presence. So I don't see that as the case. So the only evidence here is his demeanor in front of me, plus the questions that he's asked. And I don't even get to the point of whether I need to discuss whether I need to have a conversation with him, because I'm not even close to the question of whether I have a reasonable doubt as to whether he can be fair and impartial, whether he has violated any court instructions. And I've seen no evidence that he has violated any court instruction. On the contrary, I think he's been doing exactly what we've asked the jury to do, which is, if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padovano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction of the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number one from the juror. Juror number one will remain on the juror. The alternate, number 106, the retired electrician, will remain as an alternate. Okay, what's next?
Okay, motion denied. I agree with you, Jennifer. I think he was prepared with all this in his mind, and I knew that he was going to rule this way. based on the fact that he actually excused the entire jury. He let them go. So I knew that he was going to rule this way. When they were about to consent, I was shocked because I had a feeling that the jury was not, the judge was not going to excuse that juror based on the fact that he let the jury go. But yeah, I couldn't believe he stipulated to that. Somebody said, do you think Anderson, that was a show? Do you think no, I don't think that was a show. I think he spoke too soon. And then he went back and talked to Jack because the judge was about to rule on it. So let's go back and look at the jazz hands. Hold on, I got to see where that was because I didn't notice that. 8, 10, 32. Okay, who are we looking for jazz hands from?
I think I'm gonna go with that.
Okay, so what we're gonna do, with the agreement of the parties, and this is the agreement of the parties,
What?
is
What?
juror number 106 will
Did you guys
move into
see
the
that?
status of being on the jury, and juror number 1 will move into the status of being an alternate.
Which alternate? Is he just gonna swap with?
Is it gonna matter after tomorrow?
Of course it matters. Okay, I'm not going to go back. That just triggers me. It triggers me when I see them talk like that. Of course it matters. So I just want to yell at the TV. And if I'm in the car, I'm yelling in my car. Objection, objection. All right, let's go to the chat for a second. Hey, Team Brittany. Tell Dennis and Bill I said go Gators. Thank you. Thank you for the super chat. Oh, LA Cat Girl, thanks for becoming a member. And also CG in Texas. Thank you. Della, thank you for your super chat. Thank you for your coverage. Yes, please motion to dismiss, then spanking. Okay, thank you for agreeing with my order of coverage. Matt, I did thank you, but I will thank you again. Oh, Jen, thanks for gifting a member. I don't know who got it, but if you want to enable gifts, you have to go to the top of the thing somewhere over there and click a button and enable gifts. I'm not really sure. I think it's at the bottom of the screen. Maybe there's 3 dots. But thanks, Jen. That's awesome. And Teresa, new member. Thank you. Thank you. Maybe you got a DK. Yay. Good to see you, D. Pat Meacham. Thank you. Hi, Margie. Thank you so much for your super chat. Best coverage. Love Melanie in the chat. Yeah, we do have a really nice chat here, don't we? And Kate Goose Rocks. Thanks for becoming a member. Gay Lynn. So nice to see you. Thank you for your super chat. How common is it for jurors to be interviewed by the defense after a trial? I know it's not forced, but wow, feel very uncomfortable. Very common. Very common for both sides to want to talk to the jury after the case because they want to know. You want to know, what worked for you, what didn't. What did we? Is there anything we could have done to make you change your mind? You always want to poll the jury. Not only poll the jury, but even try and catch them in the hallway to see if they'll talk to you, to see what you should have done, what you could have done. What they liked about your case, what worked, what didn't. It's a very excellent learning experience, and most lawyers do it for sure. And most jurors want to talk to you too. They're anxious to talk about the case, because most cases are not on TV. But they are very serious about what they do, and of course they love to talk about it. And they'll say like that one witness sunk you, or we really like that witness a lot. They tell you a lot. And it's a great learning experience. Hi, Villaray. Thanks for your super chat. Oh, you were in court today. And Maya is a lovely, gracious Shapiro's jerk. He asked Jules in court every day when this ends, if she's going to get a life. Jules said, yeah. You going to get that vacation? Oh, really? Wow. I mean, I know that Jules calls into Recovery Addict. I don't know if she's retired and she likes to hang out in court. I don't know if she's a reporter, if she's an attorney. But hey, Villaray, if you want to call in, I'll send you the link and you can come in later and tell us what happened today or what you're observing or what your thoughts are. Happy to have you. If you want to email me at fanbase@mlittlelaw.com, I'll send you the link to the stream if you want to come in. You guys want to hear from Villaray? Yeah, we'd love to hear about what you're seeing. Hello, LB. Do we know what sanctions or whatever there will be the defense of all their pants on fire? Yeah, liar, pants on fire. Yeah. So this morning, we didn't get to that yet, but this morning the plaintiffs filed a motion for sanctions, and it is 327 pages long. But in their defense, it's mostly exhibits, and the actual motion itself is about 30 pages. And they filed it at 11 a.m., 11:09 a.m. this morning. I have a copy of it here. I don't know if you guys want to go over it, but basically it's accusing them of like withholding this stuff intentionally in bad faith, blah, blah, blah. It's got a lot of excerpts from transcripts in here. It's saying that, Anderson's testimony was based on a whole bunch of BS that his attorneys handed him and spoon-fed him. And they're looking for various sanctions, which they actually do talk about in the morning, like striking the answer is one option. The other option is, let me just scroll to like page 30, which is where it is. They didn't seal it in the court file, but it's kind of like you have to register, I guess, to get a copy of it now. I guess maybe their server crashed because too many people are trying to find it. And I really, for the love of all that is holy, could whoever is doing the motions in their office please number their paragraphs? They don't number their paragraphs. Anybody who's a lawyer, no, that's like motions 101. Number your paragraphs. The sanctions that they asked for, they gave the judge a number of things: to strike the defendant's answer and affirmative defenses and proceed to arguments on damages. What essentially that does, if you strike the defendant's answer, there is no question on liability and you go straight to damages, similar to a directed verdict. A directed verdict means that if there's a directed verdict for the defense, it means that that cause of action in the complaint is out. If it's for the plaintiff, it means that's already been decided on the law and the jury only has to decide damages. So the first thing they asked for was to strike defendant's answer and affirmative defenses and proceed to damages. The second thing in the alternative was a directed verdict on punitive damages if the jury finds in plaintiff's favor on either false imprisonment or battery. Third, striking the testimony of Mark Anderson and giving a jury instruction about his testimony. Fourth, permitting plaintiff to offer into evidence during its rebuttal the evidence obtained from them, which was like 3 boxes full of documents. You want to talk about like papering the plaintiffs to death and hoping they don't find that one little needle in the haystack that's going to bury you? That was kind of a wait, first you can't find all this stuff and you have no idea where it is because it's in the back of Dracula's closet somewhere. And then when you do turn it over, it's those big giant file boxes, they call them banker's boxes, full of documents. You turn over one on Friday and then the rest, like this morning, like 2 more boxes of documents that you didn't realize that you had. I mean, I think that some of this was in bad faith. And the last thing they asked for was plaintiff to get his attorney's fees for discovery after November 1st and for the deposition of Angela Green. And in my opinion, there could be larger monetary sanctions against the law firm that the law firm would have to pay directly, not the hospital, not their client. So it could be a real problem for them. Desert Quill, thank you for the super chat. Hunter flat out lied and worse about the IJ. I thought the defense would be sanctioned when the time is right. Would you give your opinion on this? Oh, well, we're just talking about it now anyway. The judge has reserved his decision on that. So I don't think we'll know anything about sanctions until after the trial is over. But the things that a judge can do for sanctions, usually money damages, right? It's usually they make them pay a fee, right? A fine, penalize them. How do you hurt a lawyer the most is in the pocketbook, right? 5,000, 10,000, 50,000, depending on how egregious the offenses or what they did. They can also refer it to the grievance committee, which is an even bigger problem for a lawyer because I don't know what they call it in Florida, but in New York, it's the grievance committee. And that's the committee who decides whether or not you should be disbarred or suspended or censured, which is like a little slap on the wrist, but it's public because it gets published in the New York Law Journal and all your friends can read it. So potentially could be a problem if it's found that it was done in bad faith and with intent to deceive the plaintiffs. And it's a little sticky. Hi, Laura. Thanks for the super chat. Plus, the attorneys review the questions before they ask them. They do. They do. But some of these questions, I think, as somebody pointed out to me, were not even asked. So that was the issue here. So I don't know. Hey, Fallstar, if my opponent brought ChatGPT case law, would you laugh or motion for sanctions first? And would you drink champagne or a cocktail? That's really funny. I do like champagne. But I just can't even, and I don't know how much you guys know about that case, and I don't want to digress too much, but those lawyers even doubled down on it when they were questioned by the judge. They're like, Judge, we didn't know these weren't real cases. We thought maybe they were just slip-ups and they hadn't been, published. And then they started the whole backpedal thing, and we can't afford Westlaw. It's too expensive. Oh, it's really kind of embarrassing. Hi, Sunflower Day. What's my opinion on Anderson going back and forth there before listening to Jack? Was that a ploy? No, I don't think it was. If you watch his body language, I'm not a body language expert, but he looked real nervous to me. Not nervous, but he looked like he was wavering, waffling, and then he made his decision, and then he changed his decision, and then he thought to himself, oh, holy crap, I better go ask Jack what he thinks. So I don't think it was a ploy. But it's good that it worked out the way it did. Hi, Christina B. I had this question too. Was the juror that had the medical issue an alternate or one of the 6? I didn't catch that part. I didn't either, but I have a feeling it was an alternate because there was no discussion about reseating him with another juror. So that's what I think. That is what I think. All right, now, do you want to go watch the spanking from early morning? Law and Crime. I know if you were watching Recovery Addict, as I was, his stream was the Zoom stream, and it started a little bit earlier than this one does on Law and Crime, but I didn't see anybody else. I think Tampa 13? They had the same feed. So I think maybe the TV cameras weren't allowed to go on until a certain time. So if there's anything that we are missing, let me know if you can fill in what happened right before this. I wish that my memory was better, but it's been a lot today, and I didn't take any notes this morning because I figured I'd be able to just replay it for you. But no, you know what they say about best laid plans. Best laid plans. All right, let's see what speed we're on here. It is kind of fun to watch him, but they do speak a little bit slow. So I'm going to put it on 1.5. Let me know what you think. And this is early this morning. The first thing that they were addressing was the deposition, the turning over of the discovery, the IJ reports, CMS reports. Apparently the deposition did happen Friday evening. So whoever gave us the intel on that was 100% correct. And I don't know. Oh, thanks. I got a haircut today. Thank you. Thank you very much. Thank you, Jessica. If you're watching, love you. Thank you. All right. Enough about my hair. Somebody once commented on one of my streams like, we don't care about your hair. Okay. Turn the channel. Turn the channel. It's my channel. I'm going to talk about whatever I want. Here. Well, I'm going to go full screen for this one. See? Be nice or leave. Be nice or leave. It's my channel. I can make people be nice, and the mean people are not welcome here. So if you're going to be mean and you're going to troll, and by the way, that woman Iris, anybody know who I'm talking about? I'm just going to use her first name. Well, Iris was banned from here quite some time ago because she had some unfriendly things to say in the chat, and I see her trolling other chats. And rumor has it that she may be related to one of the defense attorneys somehow. So, Iris, if you're out there, I know you're trying to put some nasty messages in there, but you're not going to see them, and neither are we. Okay, here we go. You guys know what I'm talking about. We're not doxing her. I was just going to say her, the initials are IH.
Where the parents are communicating directly with the treating, they should have. She also agreed that where the parents are communicating directly with the treating psychologist, Dr. Jennifer Katzenstein, that they have real concerns by mid-November that Ms. Beatty is improperly interacting with, counseling, advising their daughter. That issue should have been raised to senior leadership, including the CEO of the hospital. So those are the broad sweep of the failures that resulted in immediate jeopardy. It was cultural, it was systemic, it was improperly structured in terms of risk management. There was a culture of retaliation and retribution if you spoke up, and it all culminated in how Mike Kowalski was treated.
Now, I appreciate that. Where does that leave us with respect to proceeding? It sounds like you've got a lot of information already, and we need to address what the door that was opened by the defense in their case in chief.
Yes.
But
Yes.
it's, you know, we're not trying all these other collateral issues. It's just to meet what
Yes.
the defense presented to the jury, a fair shake of it, and then moving on. So can't we just do that with what you got this morning?
No.
Well,
I mean, it sounds like you got a deposition of a senior individual at the hospital. You've got, you know, perhaps you've got it late, but you've got the documents. I'm assuming that your experts now seen them.
Mhm. Can we just, is that a ruling or is that a?
No, I'm just asking a question.
Sure,
Can't
sure.
we just, do you have enough so we can just go and finish this trial?
If forced to, yes, but we don't think that's adequate. And the reason is this case has had risk management central to it since before the court came on as a presiding judge. It's been up to the Second District Court of Appeal on this issue as to whether risk managers are sufficiently managerial to have the authority to bind the hospital and a punitive damages award be appropriate or upheld. So for us to attempt to unring the bell, unwind the clock over the course of 72 hours over the weekend, we think is severely prejudicial. So we have laid out a menu of options for the court in our request for relief. We believe that this was manipulated, intentional, contumacious by a clear and convincing standard because
Contumacious, that is my favorite lawyer word to use. When else do you ever hear the word contumacious, if not in legal papers, when you are trying to say that your adversary did the most egregious thing possible? It's like the epitome of egregious is contumacious. Love that word. And I think up until this point, I know somebody said go into Recovery Addict to watch the Zoom. I did watch it this morning. I don't want to play his feed though, because that's not kind. I would never do that. But I think that Whitney had spoken up until this point, and is explaining to the judge what happened with the deposition, what happened with the discovery being turned over, and Hunter has not spoken yet. So that's really the salty part that we're going to see.
as the court noted on Wednesday afternoon, defense counsel in this courtroom serves as primary outside counsel for Johns Hopkins All Children's Hospital. Under questioning of the court, defense counsel admitted that he had an entire set of closed files on his computer. In essence, there's no way that as we were proceeding through this case, defense counsel was unaware or forgot about all of these systemic, cultural, and retaliation issues that were at the forefront in 2018 and 2019. We believe that conduct is severe enough to warrant the striking of defendant's answer and proceeding this morning on damages. If the court thinks that's too...
I'm putting my face up here because I don't like that they put her face up here, and I don't have anything else to block her face with. So just, bear with me for a minute. But everything he's saying is 100% correct. And he's saying it a lot nicer than I would have said it. I'd be like, Judge, do you really... He really expects you to believe that he had all of these closed files on his computer, and he's going to stand in front of you with a straight face and tell you that he didn't know all this shit existed? Oh, sorry. I usually don't curse on this channel. Oh, now they're going to demonetize me. But whatever. Give me a break.
Severe. We think that given the history of this case, having been up to the Second District Court of Appeal, that the court should direct a verdict on punitive damages if the jury, after deliberation, believes that we have proven battery or false imprisonment, the counts that are subject to punitive damages.
And that's exactly what it said in the motion that I just read to you. So he's going to lay out a roadmap of what he wants the judge to do, which is really like a nice way of helping the judge out instead of having the judge make a decision by himself. Is like, here's what we think you should do. Yeah. Contumacious, CONTUM. Macious, Macious. I was a spelling bee champion in 8th grade, and now I probably just blew it. All right, whatevs. Yeah, he's giving him a roadmap, and he's giving him some options, which is pretty nice. Thanks, Gamer Deco. 6 in the swear jar. Thank you. Appreciate you.
We've been unable to develop the evidence on that over the course of the past 5 years, given the withholding of information. Third, if the court believes that is not appropriate, we have suggested, and it sounds like the court may have weighed into these. So I heard something about potentially a directed verdict on negligent training. We think that could be an appropriate sanction. Third, and in combination with others, striking the testimony of Mark Anderson and giving the jury an instruction to that effect that his testimony was unreliable and misleading because even from him, material and relevant evidence was apparently withheld. Fourth.
Is that Jules right there in the white shirt? Is that Jules? Okay.
Is what the court suggested a moment ago, that we proceed this morning. We cobbled together, and we have prepared an exhibit list, if that's how we do this today, with some of the more critical documents that we received on Friday evening. And we put Dr. Corcoran back on the stand, and he has the ability to talk about these issues and how they affected the hospital in 2016 and 2017, the time of my admission. And fifth, regardless of what the court finds appropriate from what we've presented here, sanctions against the hospital, attorney's fees for all these efforts, taking the deposition. I don't know how far back that we need to talk about that, but those are our suggestions to the court.
Thank you.
Sure.
Mr. Hunter.
Mr. Hunter.
I'd like to address first Your Honor's question regarding how we proceed this morning and what's necessary to proceed this morning. And in order to do that, I need to make clear to the court most of the information that was set forth in our filing on Friday of Angela Green's affidavit, as well as the disclosure that we filed. If you go back and you look at Dr. Corcoran's testimony.
Okay, can I ask a question though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and in none of those did you attach the immediate jeopardy finding.
Bam. Did you see that? Remember, because we looked in the court file last night and it was like hundreds and hundreds of pages. And the judge called him out because the judge actually read it and said, you filed that motion and you filed that affidavit, you filed hundreds of papers, and nowhere in that filing was the actual IJ report. I need to just rewind that for my own personal satisfaction.
If you go back and you look at Dr. Corcoran's testimony.
Okay, can I ask a question though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and in none of those did you attach the immediate jeopardy finding of what brought us here. Why did we omit the actual immediate jeopardy finding from your affidavit and from the motion?
Well, the point of the affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided. But
It was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
it was not.
I mean, you attached a whole bunch of other things saying how wonderful everything is.
Yeah, you attached a whole bunch of other things. You didn't give it to me. I'm the judge, damn it. I'm the judge, damn it. You didn't give it to me. How he can even stand there with a straight face and defend himself against this is beyond the bounds of any attorney ethics that I've ever seen.
She didn't attach that.
Yes, sir, because the point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
Oh, so in my mind, Judge, I don't give a rat's ass what you ordered me to turn over, but in my mind it was immaterial, so I just didn't give it to you. Oh well, sorry. My bad. My bad. There's a lot of people always say my bad as if whatever they just did before that you're going to forgive. And the funny thing is it usually works. If somebody says my bad, you're like, all right, whatever.
So when I said to turn it over, you didn't immediately turn it over to the the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say
And
to turn over the immediate jeopardy finding, you're going to interpret that not to turn over the immediate jeopardy finding?
No, sir.
Right,
Your Honor, we
right.
turned over the immediate jeopardy
When?
finding. By Friday morning, I have a list here of about 30 or 40 different documents that we had turned over to the plaintiff in less than 48 hours after this all occurred.
Hmm.
I've also got, since then, a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition.
Interrogated her. You don't interrogate someone during a deposition, you question them. But because it was evidence that you didn't want them to find, now it's an interrogation, counselor? And you turned over 1,500 pages of documents, but you didn't give it to the judge? He's right. What am I missing here? Because like I often tell you, sometimes I'm in the twilight zone too. And I say to you, please help me. Please help me.
Regarding the immediate jeopardy finding. And the immediate jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was
I mean, when I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
Judge, my apologies for not attaching it, but again, the point of the affidavit.
My apologies for not attaching it, Judge. My bad. My bad, Judge. My bad. But I really think I know better than you, Judge, and I didn't think it was material to this case. I didn't think it was discoverable because it's going to sink my case. And I certainly don't want it out there in the public, which is why I filed all of those things under seal with the court clerk, who even called me out on it and said, you know, stuff is going to be unlocked in 10 days if you don't make a motion. This is so, you rarely see this, you guys. So enjoy this show. Maybe you want to get a little popcorn because you never see this. You guys probably watch a lot of trials. This kind of stuff doesn't really happen. And he's like fighting for his license right now. I mean, this could turn out to be something really bad. And you know that because yesterday, when we read the order from the dependency court that released Maya back to her dad in January after Beata took her own life, who was in the courtroom representing the hospital? Shapiro and Hunter. They're the only people who have been involved in this case in real time since 2016 when it happened. So for him to say that he didn't know that this stuff was out there and that he didn't know that his hospital that he's been defending for how long was in immediate jeopardy with a 3-year look back is a little more than disingenuous, in my opinion. In my opinion. Come for me in the comments. Come for me in the comments. I've got merch that says that too, if you like it. Come for me in the comments.
And the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue.
Oh,
What I was trying to get across to Your Honor, obviously unsuccessfully, is the fact that
obviously unsuccessfully. You didn't try and get anything across to me. You tried to hide it from me. This judge isn't stupid. This is like he's insulting the judge to his face, insulting his intelligence. This is not going to fly well in the future.
the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a quote, look back unquote. First of all, there was no survey in September 2018. And secondly, the surveys don't look back, they look forward. And that's the second point of the filing. It was to establish the fact.
Help me here. How would a survey look forward? Corrective actions would look forward, but a survey is looking back on what already happened. Like he is so, and He knows what he's saying is completely wrong. Am I wrong? Am I wrong? Anybody? 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 Come for me. Somebody. Is there another attorney in the chat that practices actually in Florida that can tell me that I'm crazy?
At the time of Maya Kowalski's hospitalization, what Dr. Anderson or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JACO and CMS. The point of the filing was that we documented that that was in fact the case, that certificates had been issued in 2015 and in August of 2018, indicating that we had been reaccredited, that that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by
Congratulations, you got your accreditation back. Like he wants us to like pat him on the back. Oh, good job, Hunter. Good job. Good job, Hunter. He lives in the upside down. That is, if you can make me laugh during this stream, you win a trophy. Cynthia Main, you're in the running for #1 right now. Yes, he's mistaking survey with forecast. This, you just can't make this up, you guys. We could try and script a mini series on this, and we couldn't. We'd have to use his words. We'd have to. Who would you want to play him in the mini series? Put your comments below. Who plays Hunter? Hunter.
Mr. Anderson's testimony, Ms. Kowalski's hospitalization was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital at the time of Maya Kowalski's hospitalization, is simply not true. There was not, the immediate jeopardy did not relate to any of that. The immediate jeopardy did not base its findings on anything that took place during Maya Kowalski's hospitalization.
Because they didn't mention Maya Kowalski by name? You were in court, Hunter. You were in court during the dependency hearing. And are you trying to tell this judge that because Maya Kowalski may not have been mentioned specifically in this Joint Commission report or the CMS report, that it doesn't relate to the time period that she was in your hospital? Oy.
Or that was even reviewed at that time. The point we were trying to make, simply put, is that Mr. Anderson's testimony, however brief and however summary, was simply correct to the extent that we were in fact accredited at that time, and that there was nothing untruthful or misleading presented otherwise to this jury. That was the point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How
There
do you
was
say
not-
that? I mean, am I just to take your word for it? I mean, what? How
Am I just to take your word for it? Yes. Thank you, Fran. Hold on. So Fran is a nurse, and I'm pretty sure she knows about this. If they found something egregious or a violation, you're given 24 hours to fix. If it's not corrected, you go into immediate jeopardy payment, and they were there. Payments are held, right? They lose their accreditation for Medicare and Medicaid, right? But isn't it a 3-year look back? Am I just supposed to take your word for it? Oops.
how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided that actually indicates what the basis of the IJ was. And it talks about interviews, and it talks about evidence that was gathered in January of 2019 during a site visit between January 7th and January 11th of that year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report. He saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that that was not a look back situation. So the whole premise of this, the whole point of this is not what was going on at the time of the IJ and the findings that were made regarding the IJ in January of 2019. The point of this case and the things we're trying to litigate here took place in the fall of 2016.
The whole point of this, Your Honor, the whole point of this is that this is going to kill my case. There's going to be so many zeros on this verdict that I am not going to know what to do. I could lose my license. I could lose my biggest client and everything that I have, Your Honor. Wow. I have not seen any good suggestions for who gets to play him in the movie. Thank you, Larry. That's the actress in me. I feel like every lawyer is a frustrated actor, and that's what I did. I wanted to be an actor when I was a kid, and I didn't. I went to law school instead because I thought I could just write my own script and still get to perform in front of a jury. And does this make anybody else mad? This makes me mad. I don't know. This makes me mad.
2.5 years before. And there is not anything that has been produced that I'm aware of that relates the IJ or its findings or its basis to what was actually happening on 7 South or 7 North, where Maya Kowalski was a patient in 2016. The proof that we put forward in Angela Green's deposition, and she's here to testify if need be today, Judge. The proof that we put forward, simply put, was that the IJ related to the self-report of the Heart Institute and the Heart Institute alone. If you look at the report, if you read the report itself, you see talk of governance, you see talk of infection control, you see talk about contractual duties. But when you look at when the interviews were in each item of that report, it talks about interviews that were conducted in January of 2019 and the findings that were made in looking at documents over at that period of time or over the preceding 4 to 6 months. It says nothing about looking back 3 years or 2.5 years to this period of time because it simply didn't.
Did Ms. Crane lose her job because of this issue?
Ms. Crane lost her job because of the Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off. And I want your question.
I want your question, Judge. I didn't mean to cut you off. I just realized that I told you to take a look at the report, which I didn't give you. Here, Judge, take my copy.
I really do. The point of this is, however, if you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off. And I want your questions. I really do. The point of this is, however, that if you look at the sequence of events here, there was in fact a self-report to the Joint Commission. It was oral, and then it was supplemented with a written report. The other two reports.
The self-report occurred because there was a media report out there already. Is that correct?
That is true, but there had been reports and.
Yeah, because what was it? The Tampa Bay Times did a huge investigation, and that's the only reason there was a self-report. Yeah, we know that. And wait until Dr. Corcoran's testimony, because that reporter was nominated for a Pulitzer. Oh, is Christine in the chat today? Christine's niece is married to Dr. Corcoran, the star witness.
There had been discussions beforehand.
Well,
If you
wait a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
there was a report and a review that took place in the spring of 2018.
A report. Who's reporting what to whom?
There was a media report then regarding a heart case. that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done and there was a follow-up and the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of 2018. Those documents were attached to the motion. There was none of these deficiencies found or identified at that time. So what happened here was there was concern.
So what had happened, Judge, was I had meant to put the bill in the mail, but I just didn't. Do you guys remember that? Crank Yankers? Crank Yankers was some of the funniest comedy ever. And that's what, like, they should make a Crank Yankers episode out of him. Wow, there's a lot of comments. All right, why do they have to just focus on Maya so much? Like, leave her alone.
Regarding the heart program, there was an effort to address that. The regulatory authorities came in, they did a survey, they found the deficiencies addressed. There was a subsequent triennial review in August of 2018 that resulted in a reaccreditation that renewed the accreditation that was in effect at the time Ms. Kowalski was in the hospital in from September of 2015. So at the time of her hospitalization, the hospital was in fact accredited by the Joint Commission. It was in fact accredited and in good standing with CMS. There was no indication otherwise. Those facts were reaffirmed in August when there was another triennial review. When this hit the fan, so to speak, with a media report,
Oh, it hit the fan.
It was self-reported that day, and 2 weeks, 3 weeks, nearly a month later.
Right, when it hit the fan, we self-reported that day because we knew, because we were getting calls from the reporter from the Tampa Bay Times, Your Honor. So we knew they were onto us, and we had to quickly self-report so we could try and get ahead of this, based on my advice. Because, you know, risk management wasn't even available. Not only were they not available in real time, but Dr. Napolitano, who's on the risk management committee, who was their witness, testified that he didn't read about the Maya Kowalski case until 2023, April, in USA Today. He didn't even read about it in the Tampa Bay Times. So you know what those guys are doing. Not managing risk.
Later, CMS came in with an unannounced survey and made their report. They left. They did not find an IJ at that time. They issued the IJ on January 31st, 2019. We had 10 calendar days in which to respond. We responded. There's all this correspondence has been provided. That the issues that were raised in the IJ, according to what we sent to them at the time, correspondence from one of our senior officials, said basically, here's the plan we had already put in place by the time of the report. Changes were already underway. Here's the plan we had already implemented. Then, in addition to that, there was a proposed plan of action to address the IJ and address the deficiencies. That document was provided. Then there was another on-site visit that took place in February 20th and 23rd, I believe, of 2019. That resulted in the IJ being lifted with a plan in place that we had to abide by. We abided by it. There were subsequent follow-ups, and it was cleared. But the IJ was lifted, Judge, in February of 2019 by CMS. And obscured in all this is the fact that
Obscured in all this is your argument, Hunter, because nobody has a word. Nobody has any idea what you just said. Anybody ever date a narcissist? You know what word salad is? That was the biggest tossed word salad that I've ever heard. Anybody can anybody help me interpret that? Like, we had it, but we didn't have it. But then they gave us one, and then we self-reported it, and then they gave us, and then they had it, and then they took it away, and then we did it, and then nobody has any idea what he just said. Good thing the jury wasn't listening to this.
at or about the same time that CMS was conducting its follow-up survey regarding the IJ, the Joint Commission was also in to do a follow-up review, and that was cleared. There were no deficiencies found. And so what I'm trying to get to is this, and the point where we can show you what happened with the IJ, we can demonstrate all that, but what I don't want to get lost in all of this is this central bottom line fact.
We can show you all of that, but we really don't want to, Judge. We can show you all that, Judge, but we really don't want to. because we know it's not good for us. Oh my God. All right, I'll do a poll when I get enough enough contenders to audition to play the role of Miss Santa. Oh, for the love of God. Okay, onward. This is the best laugh I've had in a long time.
Into this conversation today is the question of whether Mr. Anderson's testimony about the standing of the hospital regarding JACO or CMS, whether his testimony was incorrect or misleading. And the answer to that question is that it was not. And there's no basis, there's no indication in the record otherwise. All you've got to suggest otherwise is testimony that is based admittedly on supposition. Okay? When Dr. Corcoran,
Yeah, I love how he works for a hospital and he refers to so many of these doctors as Mr. instead of doctor. And I find that really disrespectful. Let me know if you think I'm wrong about that. Mr. Corcoran. Guy's a doctor. He worked his ass off for it. All right, give him the respect he deserves.
testified, he indicated that he had never seen a joint commission document regarding an IJ. He had never seen any indication that there was in fact some survey in September of 2018. And that's for good reason. There wasn't.
Yeah, because you know what he did do? He read the Tampa Bay Times or the Tampa Times, whatever. I'm sorry if I'm misnaming the paper. Yeah, because Dr. Corcoran is smart. And the Joint Commission reports aren't public. Okay.
One. And the point that I'm trying to get across to Your Honor is that at the time of this hospitalization, there was in fact a certificate issued that had been issued that had never been revoked and never been abrogated, that Johns Hopkins All Children's Hospital was accredited by the Joint Commission, and there was no indication from CMS otherwise.
But when did they take over that hospital? Anybody know? 2012, maybe? 2011 or 12?
So what is your suggestion, your game plan for today?
My suggestion, Your Honor, that if this issue is that problematic, that the jury be instructed to disregard Mr. Anderson's testimony with reference to JACO and CMS, and that we proceed. We would like to go ahead and proceed with the case. If at the most, if we believe that putting this entire issue before the jury, first of all, is going to result in more misleading and more confusion than anything we could possibly do otherwise. We've been trying over all this weekend to conduct discovery and conduct what amounts to a reopening of discovery with reference to matters that are fundamentally immaterial and that are fundamentally prejudicial in the.
We've been trying all weekend. I got news for you, Hunter. The plaintiffs have been trying for 5 years. So thanks for giving up your weekend to give them the documents they've been asking for 5 years. We appreciate your tenacity and your dedication to this case. And now you're going to mischaracterize it as in saying that has nothing to do with this case?
Sense that any prejudice far outweighs the probative value. We've been litigating and investigating a purely collateral matter. And Judge, I think we're at a point where the best and most conservative management of this situation is to proceed. And if there is some clarification, limited clarification that counsel feels a need to address and rebuttal, then let's do that. But I would implore the court to look at the circumstances and look back de novo at what Mr. Anderson actually said and what Dr. Corcoran actually said, and see that there isn't any indication that this jury was misled. There is a brief reference to this entire matter, and we're going off into a collateral matter that is going to be fundamentally confusing and highly prejudicial. And if we go down this road, we're going to have more problems than we could possibly imagine.
So when witness Mr. Anderson is asked the following question, let me talk to you about your overall view based on what you've reviewed. Did it appear to you, based on the materials you reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor,
so I mean, that is something that the hospital adduced in front of this jury.
Mm-hmm.
yes, sir. And at the
And
time,
now you're telling me the door was not open.
And Your Honor, that's the summary that we gave him to testify from. We gave him a script, Your Honor. It was 3 pages long. It was 3 pages long, and he said exactly what we wanted him to say, and no more.
I mean, that's what you're telling me?
What I'm telling you, Judge, is 2 things. Number one, if he were to be called back, if we can get him back, if he were to be called back, the proof would be that at the time that he
Okay, is Mr. Altenburn sleeping over here? Is he sleeping or is he taking notes? Anybody know? Did Jules report on this?
referenced that statement
Oh, there he's awake.
as of the fall of 2016 and 2017, the Joint Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's
Let me ask
certificate
you
proof.
this.
And then,
Let me catch up. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
yes, sir. We sent,
He was provided the information?
I,
Because we had an issue
No,
with
no.
what was produced to Mr. Anderson, witness Mr. Anderson. So I want you to be very clear as to
Uh-huh.
what was specifically produced to witness Mr. Anderson.
Yeah,
Very, very specifically.
Yeah.
since Wednesday.
because if you're not very, very clear and you don't tell me the truth about this question that I'm about to ask you right now, Mr. Hunter, you will be referred to the grievance committee before lunch. Listen to his response.
Since Wednesday,
Since
he was sent
Wednesday.
the certificates.
I don't
and the
care what
plan.
happened since Wednesday. At the time he testified to this jury, had the defense even provided any of the information that we've been discussing since Wednesday?
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you want to step into the breach here?
May I throw Mr. Shapiro under the bus, Your Honor? May I throw him under the bus because it was his job to give Mr. Dr. Anderson all of those documents. So, could they do a Saturday Night Live skit on this? Maybe on Saturday, or do you think it's not popular enough for that? Do you guys watch SNL? This would be really funny. I could see Keenan in there somewhere because that would be hilarious.
Well, only to the extent that he was provided hospital policies and procedures yesterday.
That doesn't answer my question.
I did not provide him joint commission surveys, no. So I don't know if he looked at anything online, but to my knowledge, no. My understanding of his testimony, well, just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at the time meant that they had gone through joint accreditation surveys. That was the simple basis of the statement that he volunteered.
Didn't even provide the information. Okay.
And we've been saying that all along. Never let him see his sweat, Shapiro. Could you imagine the size of the baloney stains on his button-down shirt underneath his jacket right now?
What's next, Mr. Hunter?
I just point out to the court that we have been scrambling very hard to try to provide as much information as quickly as we can. And I believe that this issue can be addressed either with an instruction, a curative instruction, or some summary disposition. I think if we go full scale into it, we're opening a whole nother trial.
Well, plaintiffs are telling me that if I don't go into it, I'm getting another entire trial anyway. Okay, we are where we're at. Anything else, Mr. Hunter, that you would like to say before I let Mr. Whitney have a very brief rebuttal, and then we'll talk about what we're going to do.
I don't believe so, Your Honor.
Mr. Whitney, very brief, please.
I need to dispel a couple of notions. First, that these issues were limited to 2019. In what was produced to us Friday evening during the deposition, we have an ACA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient family education. That was less than 1 month after Maya Kowalski was discharged. We provide that the first time from ACA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back. And in the corrective action plan at page, I don't know what page, I can pull it for the court if we need to. The Patient Safety Committee reported 12 retrospective Code 15s and additional Code 15 reported during the required timeframe. They're not talking about the future. They're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart, included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program. There was found to be retrospectively no evidence of risk management reports or data collection in the past 15 months and no historical data related to objective indicators of quality, all retrospective. The failure in the plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP chief of staff functioning as lead executive of risk management, the chief patient safety officer, and the VP of marketing and communications and culture. The director.
Oh, wait. Somebody needs to make a meme with like something above his head, you know, like caption the meme. All right. That's the next contest we're going to have here. Caption the meme right here. What is Hunter thinking if he had a bubble over his head right now? Sorry, you guys. It's turning into a comedy show.
The officer and the VP of marketing and communications and culture. The director of risk management was replaced by someone in the role of vice president of medical affairs. Mr. Anderson's testimony, you know what, the court already spotted the issue, that exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case. For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now and have a mini trial on this issue. We think directed verdicts are the appropriate remedy.
Amen.
The court has before it the question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now. What
Nobody knows, Judge.
not to do.
Judge, I submit to you that we are in the twilight zone right now. We are in the twilight zone, Judge. Oh, I can't get rid of your comment, Della, but it was a good one.
I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine at the hospital at the time of Ms. Kowalski's admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more pervasive than just isolated to the Heart Institute. There's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, and I hear what the defense, they want to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins' purchase and acquiring of the hospital, which was, I think, 2011 or 2012. So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury. Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented. And then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have, 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report, but be that as it may, we'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his
2 more
here
boxes.
that you spend this morning going through.
2 more boxes they need to go through now. And this was what? It was 38 minutes in. When did this stream start? On this channel, maybe 8:30. So it's like 9:15. He's like, oh, 2 more boxes. That's okay, Dr. Corcoran, right? You can go through these 2 boxes and be prepared to testify on it. Maybe around before lunchtime.
The documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning.
Yeah, that's
So-
not going to happen like that.
Mr. Whitney,
I was only going to,
thoughts?
yes, I was only going to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all of that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here, there's enough to put in front of him to discuss this at a high level now.
Strike his testimony, though.
And
As counsel said.
And the other remedy, of course, striking his testimony. But in terms of timing, that's what I'm speaking to right now, is we prepared an exhibit list with 5 or 6 of these critical documents. We can get the issue in front of the jury for rebuttal this morning and hopefully wrap this thing up.
May I be heard for just one moment, since I'm the one delivering the closing? Judge, we can't unring that bell unless we strike the testimony of Mark Anderson. If the court recalls, juror number 1 asked a question which reaffirmed their point about whether the government had passed.
This guy, what did you guys tell me his name was? Mr. Reyes, I think. He is the brains behind the whole operation. I have a feeling he is getting all of it done. Love that guy. He's like the silent type who knows it all. All right, so spoiler alert, Dr. Corcoran has to be at a doctor's appointment at 2 p.m. And so they are gonna review these documents and they're gonna put them on the stand for a rebuttal, and they're gonna get all that done before lunch. I think, in fact, he might have even. Yes, they do not make their reports public, Nurse Jones. Joint Commission does not make their reports public. You are correct, which is why Dr. Corcoran couldn't find them. So they are going to let him rebut. Would you like to watch his rebuttal? Because we're only at 39 minutes and it's all the way at 3 hours and 30 minutes. So I think we should skip to that unless you want to watch a little more of the spanking. But I think we should get there.
Judgment or had accepted, or whatever you want to call it, approved of the actions of Johns Hopkins, that there were no problems there. You can't unring that bell unless we do something to let the jury know that that was highly questionable testimony. Because even if you come back here with some rebuttal, it's still in the jury's mind that the other guy said, well, but the government overall, they found that they were okay. And I know juror one, at least, who's asked the most questions, has been, I mean, it was a concern to him. So we moved the court to strike.
Oh, remember, this was before they decided to not dismiss juror number one. All right. Yes, I think we are going to go to Dr. Corcoran's testimony. As I predicted on the day that we did the Battle of the Experts stream, I predict that Dr. Corcoran was going to be the star witness, because when you put him right up against Dr. Mark Anderson, it was kind of embarrassing, and we did that all in one stream.
Okay, please be seated, everybody. You did no investigation and received no information. Is that all correct? Correct. Didn't see any media accounts. Is that correct? Correct. And no one approached you. Is that correct? Correct. Okay, Mr. Whitney, your next witness, please.
I just call Dr. Joseph Corcoran.
Tell me if you think it's too fast, okay?
I do.
I didn't do that with the volume. That's their volume, so you might have to turn your device down.
Good afternoon, Mr. Whitney.
I promise this will be the last time.
Promises.
Let's talk about how Johns Hopkins All Children's Hospital was managed during the time of Maya Kowalski's admission. And specifically, I want to touch on how risk management was integrated into the hospital's organizational structure. Let's start at a high level. And the jury has heard some discussion of the Joint Commission. Would you reaffirm for the jury the role that the Joint Commission plays in hospital accreditation and governance?
Yes, so the Joint Commission is a nonprofit organization that evaluates hospitals and other healthcare entities on a recurring basis to make sure that they are in compliance with the regulations, conditions of participation that are really the owner's manual to how to run a healthcare facility like a hospital.
And you just mentioned conditions of participation. Are those derived from federal regulatory guidance?
Yes, they are. So conditions of participation are actually published by CMS, the Center for Medicare and Medicaid Services, and they really form the foundation or the backbone of the accreditation process.
So we have the Joint Commission, it's a private entity. We have CMS, it's a federal entity. And then in Florida, is there also a state regulator that looks at these issues?
There is. The Agency for Healthcare Administration, also known as ACA, is based in Tallahassee. They oversee licensure and regulatory compliance for the state.
Now, with respect to the governing body of Johns Hopkins All Children's Hospital, have you come to learn about self-reports of deficiencies at the governing body level to these three entities?
Yes, I have.
What have you learned in terms of self-reports to start with ACA in December of 2018?
I understand that the hospital leadership, sometime around the Christmas holiday, but probably just prior to, actually went to Tallahassee to address in person issues that had been identified within the hospital that put them at odds with the conditions of participation.
Was there also a self-report to CMS?
Yes, in the week prior to Christmas 2018. ACA was also in December of 2018. But in the full week prior to Christmas of 2018, a leadership group also traveled to Atlanta, which is the regional office for CMS, and had a similar conversation with the federal regulators about shortfalls that that had been identified inside the program.
And then, given these issues and these self-reports, did the Joint Commission also become involved?
They did. And that was done through a self-report that I believe was done either electronically or in writing on or about the 28th of November, 2018.
And so you had then both the federal and the state entity and the private nonprofit Joint Commission looking at and scrutinizing the hospital's management structure at that point?
Well, yes, they were looking at it from that point, but there also had been some visits earlier in the year as well.
All right. Did these issues manifest for the first time in December of 2018?
No. My understanding is that the issues were first identified at the end of 2015. So they were not new issues.
Let's walk through the timeline with some documents. So if we could please display 2811A, page 1. Dr. Corcoran, at the top of 2811, I see a header that says Agency for Healthcare Administration. Is that the Florida agency you talked about?
Yes, that's ACA.
Judge, I'm sorry, this doesn't say A, so I'm trying to make sure I'm looking at the right document.
2811 was not redacted.
I thought you said A.
I'm sorry. My apologies. 2011. All right, we're looking at 2011, Agency for Healthcare Administration. And below the Agency for Healthcare Administration, right there, if you could keep that where it was, what is this document? It says in the top left box.
Correct. This is a statement of deficiencies and a plan of correction.
And if you could note the date on the right side there for me.
February 23rd, 2017.
And so what's the relationship to the date of discharge of Maya Kowalski? Is that approximately a month and a half?
Yes, sir. About 6 weeks.
And this is a good, so just keep it like this, please. And then the last two paragraphs we can see there on the left side, where were the deficiencies identified within the hospital?
In the risk management department as part of a risk management survey.
All right. If we could now display exhibit 2815. I see CMS at the top right. Is this the federal agency you were referencing?
Yes, sir. Centers for Medicare and Medicaid Services. That's the federal regulatory agency.
And this letter or notice is dated January 31st, 2019. And who's it addressed to?
It's addressed to the interim CEO of the hospital, Dr. Kevin Sowers.
Have you come to learn when Mr. Sowers took on the position of interim CEO at Johns Hopkins Children's Hospital?
He became interim CEO in December of 2018. I'm not sure of the specific day, but it was in December following the departure of the previous CEO.
And who did he replace?
Dr. Jonathan Ellen.
And how long had Dr. Jonathan Ellen been the CEO of Johns Hopkins Children's Hospital?
Gosh, 6 or 7 years, if memory serves.
So Dr. Ellen would have been the president and CEO of Johns Hopkins Children's Hospital during the time of Maya's admission.
That's correct.
And if you could zoom out a bit for me, and that's a fine view there. In the second paragraph in the letter, it references a determination of immediate jeopardy. Do you see that?
I do.
Would you please explain to the jury what immediate jeopardy is?
So when deficiencies or non-compliance with the conditions of participation, the rule book, when those deficiencies are considered egregious, widespread, actually it's defined further down as, could you scrap that please? It's defined as an immediate or serious threat to patient health and safety. So an immediate jeopardy is as severe a finding and it carries an equally severe threat if an immediate jeopardy is not remedied quickly in a timely manner. You're 10 minutes, you're given, with immediate jeopardy, you are typically required to provide an immediate mitigation plan before the survey team leaves. You then have to send a corrective action plan within 10 days and have that largely executed within 23 days. If you fail to meet that 23 days, you potentially lose access to all funding from Medicare and Medicaid.
Is it more or less a death threat to a hospital?
It is a financial death threat to a hospital. Yes, sir.
I'm sorry, what's the legal base leading, Your Honor? Or
Is there any classification under CMS evaluation and survey more severe than immediate jeopardy?
None that doesn't involve literally taking over the hospital.
All right. If you could drop that and then pull up the bold text there, the 42 CFR sections for me. Now, a few moments ago, you referenced conditions of participation.
Yes, sir.
And we see here reference to the federal code of regulations. Are these the conditions of participation you were referencing?
Those are 4 of them.
All right. And why are these 4 on this document?
Okay, so the immediate jeopardy was centered on 4 specific shortfalls in their exercise of meeting the conditions of participation. Governing body is the interaction of, the board, which has ultimate responsibility for the entire facility, and the 2 primary parties, the medical staff, represented by the medical executive committee, and the administration or management of the hospital, which starts with the CEO. QAPI, quality assurance and performance improvement. That is making sure that we're staying between the guardrails and delivering good care.
I'm going to stop you there.
Thank you.
All right. So if you look at these 4 things, these are the specific deficiencies that Johns Hopkins Children's Hospital was found to have exhibited or demonstrated at this time.
These were the areas where their deficiencies were so egregious and widespread that they contributed to this immediate jeopardy. Correct.
All right. And have you had an opportunity to hear the VP of Patient Safety and Quality discuss these issues?
I did.
Who was that?
Ms. Green,
What was her first name?
Virginia.
Okay.
Is this a quiz?
Does Angela sound right?
Angela, sure. I'm sorry.
That's right.
I apologize to Ms. Green.
In terms of having been issued a finding of immediate jeopardy, did Ms. Green conduct a retrospective review of hospital records to see where these deficiencies should be placed and the responsibility placed?
Yes, she did.
And how far in retrospect did she look back to determine where the hospital had fallen short?
She said that one team in the hospital went back 3 years, and I believe that she took her response back 5 years.
Party admission. And so whether it was 5 years, so they're conducting this retrospective review in January 2019, receiving this letter.
That's correct.
It would take us back on the 5-year basis to January 2014,
That's correct.
or on the 3-year basis to January 2016.
That's correct.
In their review, without getting specific, were specific deficiencies noted in that retrospective review?
There were.
And generally, did those have to do with adverse patient outcomes?
They,
We'll be on scope. Sustained on that one.
All right, I'll move on. Let's put up 2817, please. Now we're going to get into some of the internal communication at Johns Hopkins that surrounded
Should be 2817A.
2017.
Sorry, you're right.
No, thank you. Okay. So here it's 2017A. We have an email from Ms. Green dated February 25th, 2019. So this would have been just following the notification of immediate jeopardy. Is that correct?
about a month after.
And then we can see there her position at the time. What is the role within a hospital of the Senior Director for Patient Safety and Quality?
Well,
Objection, Your Honor, foundation.
Overall,
as the title suggests, they lead a team whose primary objective is to make sure that the care as it's delivered is delivered in a safe manner, above all else, do no harm. And so they are responsible for making sure that the care is safe and the quality of the outcomes are optimized.
If we could advance to page 3 of 2817A, please. And if you could get a whole page view for page 3. All right. So I want to focus for a moment first on the subject line at the top of this email. It says, how about this for Kevin's talking points to the board on CMS 2567? Now, here, who is Kevin?
She's referring to Kevin Sowers, who was the interim CEO that replaced Dr. Ellen.
And the CMS 2567, is that defining of immediate jeopardy?
CMS 2567 actually refers to the form number. Government issue forms always have an ID number on the base, and CMS 2567 is the page, the report that the findings are actually published on and made available to the hospitals.
All right. And so in the middle of the page, there's a paragraph that's short. It says there are 4 major areas we are actively working to improve. Would those map back to the 4 conditions of participation we saw a moment ago?
They do.
All right. Let us advance to page 5 of this exhibit, please. And we're going to talk specifically about the governing body and what types of issues were noted within the hospital during this retrospective review. The first bullet point under governing body, if you'll read that to yourself. And my question for you is, what have you learned about what was lacking between the message and the elevation of information between the president and the board in the previous 3 years?
So again, the board has the ultimate responsibility to make sure that everything is running as expected. It was demonstrated through this process that there was poor communication where problems were not shared appropriately. They weren't shared between, remember we talked about divisions, they weren't shared laterally, they weren't shared up. And they were certainly not getting shared to the board. So the board really was not able to do its job of overseeing the quality of care.
And then if we move down to the third primary bullet point, there's a smaller one in between, that's why I said primary, but it begins with structuring of risk management to report directly to the health system. When Ms. Green or Ms. Franklin references reporting directly to the health system, what is she referencing there?
She's talking about having a direct link of communication to Johns Hopkins Health System in Baltimore. Prior to all of this, Johns Hopkins All Children's Hospital was the only one of the Hopkins affiliated hospitals that didn't have that link. In other words, at Johns Hopkins, everything was by design kept locally and was supposed to be managed locally. This gave them an opportunity and access to the expertise that is that candidly is one of the things that Johns Hopkins is really known for around quality and patient safety. So it was giving them access to that expertise.
So just so I make sure I understand, there are several Johns Hopkins hospitals within the Johns Hopkins Health System.
Correct.
Johns Hopkins All Children's Hospital is one of them.
That's correct.
And it was discovered during this process that Johns Hopkins All Children's Hospital was the only Johns Hopkins Health System hospital where risk management at the hospital level was not reporting to the system. Is that right?
That's correct.
Then if we move down 3 from the bottom, it says the revision of the complaint and grievance process. There's been some discussion in this courtroom about the complaints made by the Kowalski family. What is the proper operation of the complaint and grievance process as it relates to risk and patient safety within the hospital?
Check your down scope.
Ha.
So a grievance actually is recognized as having specific responsibilities. As a hospital operator, if my team received a grievance, we were required to answer that grievance within 10 calendar days. And there were, again, communication issues where grievances and complaints, like the Kowalskis shared with members of the staff at All Children's were just not addressed at all, let alone in 10 days.
And then the last I'd like to focus to on this page is the last bullet point. It says massive education campaign on speaking up and speaking out. Have you had an opportunity to hear Ms. Green discuss this campaign?
I did.
What was the genesis of this massive education campaign?
So she described that members of the care team in a variety of positions, if they raised awareness of something not working, whether it's an outcome or whether it's a glitch, there was, number one, it was difficult to get an audience. And when you did open your mouth, she cited examples of where there was retribution against.
Okay, finally, there's a document here that's clear enough for me to read to you. So the highlighted portion says revision of complaint and grievance process to integrate service excellence reporting with risk and patient safety. As you know, all of Maya's and her mother's complaints went unheeded, unheard, and there was nobody to complain to or receive complaints because the risk management committee didn't even meet. The other thing is massive education campaign on speaking up and speaking out without fear of retaliation. So there was a culture in the hospital wherein the employees were afraid to speak out. Nobody could be a whistleblower because they were fearful. And this was a huge, pervasive issue in the hospital, as was the finding in this report.
A whistleblower, a complainant.
Oh,
This speaking up and speaking out was a program that they put in place, kind of like see something, say something. And it was to change that. It was to encourage people to speak up when they see something wrong.
Was this because there was a culture of retaliation and retribution previously?
Yes, sir.
Leading to false conclusion.
On both instances.
If you could repeat your answers in case.
Yes, there was she spoke of a culture of retaliation and retribution.
Against internal employees.
That's correct. Anyone who spoke up did so at significant risk.
If we could advance to the next page on page 6, please. Here, Ms. Green, Ms. Franklin references multiple town hall meetings. Do you see that reference in the last bullet point?
I do.
Have you had the opportunity to review some video of those town hall meetings?
Yes.
What were acknowledged as several of the hospital's failures in those town hall meetings?
So the town hall meetings were hosted by Dr. Sowers, Kevin Sowers, who was the interim CEO that followed Dr. John Allen's departure. And he was very candid about where they were falling short and basically promising to do better. He acknowledged that their shortfalls in governance were, I believe the term was substantially contributed to prior lapses in care. He talked about why they got the IJ, what was involved, and how they needed to turn things around. He characterized at one point that Hopkins let us down. And I think he was speaking for the Johns Hopkins All Children's Hospital community when he made that statement.
You threw in the middle of that IJ.
Yes.
Define what that acronym is just in case.
Again, I'm sorry, immediate jeopardy. That's the financial death threat that I referenced earlier.
All right. If we could advance to 2818A, beginning at page 069, please. Yeah, first one, first page. If you'll just zoom out so we can see the whole page, please. All right.
Hey, thanks for coming.
Now-
I watched you all morning.
Am I correct that this is
Oh, it deserves pausing the stream. Look who's here, everyone. How are you? Yeah, it's been crazy. It's been a crazy day, right? I don't like how they keep focusing on Maya, and I like how you put on your stream, you put a picture of a tree or something. I thought that was very kind of you. Instead, I
Form
just
2567 that was discussed earlier?
make her
You can see on the
smaller.
bottom left, it says Form CMS 2567. Yes.
So this would be the document that CMS speaks to the hospital through about where the deficiencies were noted.
That's correct.
And am I correct that in the left column, on some pages, you'll have more description of the deficiencies, but in the right column, you'll have the hospital's efforts to correct their deficiencies?
That's correct. So the left side is where they cite in the first column, they cite the specific standard or condition of participation where the hospital is not in compliance. In the wide column to the right is where they will describe, this is the standard, this is what we saw, this is where you're not meeting expectations. And it tends to be fairly specific. To the right of that, the broad column is where the hospital writes in their plan, their corrective action plan to address that specific element of the shortfall.
And Mr. Reyes, if you would, there's two bullet points there on the right in the right column is bold text. If you could just pull out the bold text for each of those so we can focus on those. All right, so this first bolded bullet point speaks to the organization as it related to the risk management department. What did you learn about the failures and the ways that the hospital integrated risk management into their division level operations?
So this points out that risk management was not included in the process.
They weren't even on the chart, Your Honor. They weren't even on the chart. Not even included on the organization chart. That's how little respect we have for risk management. That's how little we needed. That we didn't need risk management. We had people like Sally Smith coming in and telling us what to do. We didn't need any risk. Risk management. Who needs that?
And further down in that paragraph, it references before that bullet point, it says the JHatch functional org structure chart, was updated to reflect the relationship of the MEC. What is the MEC in this reference?
Medical Executive Committee.
All right. So
and they oversee the medical staff.
And so it was at this point, having the deficiencies been noted, it was the org chart was restructured so that risk management was properly reporting to or talking to the MEC, medical staff, the president, the board. Is that right?
That's what it indicates, yes.
And then the next bullet point, if you read that to yourself about no evidence of risk management reports, and describe to the jury, please, what kind of failure that indicates.
This was very surprising. It indicates that over 15 months prior to the survey, that there was no demonstrated effort to track and trend what was going on in the hospital in terms of quality. I think Dr. Perno and Dr. Napolitano both talked about tracking and trending as the key function of the risk management committee, which is different than the risk management department. And if you're not collecting data and if you're not sharing data, it's impossible to do that. So the idea of tracking and trending is if you notice something that starts to go off course, you push it back on course before it drifts way off course. So without the tracking and trending, there really were no guardrails effectively.
If we could advance to page 72 of it's 3 more pages. Next page. And the top, that's perfect. Read that first bullet point to me, if you could.
Starting with according?
Yes, sir.
You want me to read it out loud?
No, I just want you to read it yourself.
Okay.
And explain to the jury the significance of adverse medical incidents residing with the risk manager and not being elevated.
Right. So adverse medical incidents covers a variety of harms that occur in the hospital, impacting mostly patients. And so it looks like those harms or adverse medical incidents got to the risk manager, but again, they weren't shared, and they weren't shared up to leadership. Jackie Crane was over the risk management department until her departure. And there was no portal until after corrective action was put in for these to be shared at a system level. So, I mean, it's metaphorically, it's the equivalent of just being stuffed in a drawer.
And you mentioned there Ms. Crane, who was senior counsel.
She was.
And when these issues were finally discovered by the federal regulator, was she removed?
She exited at the time that Dr. Ellen exited.
Now, this document is quite detailed, and the jury will have at least 16 pages back there, so I'm not going to go through every specific deficiency. Let's move to 2819. 2819A. Excuse me.
I was ready.
All right, so here we have an email from Ms. Green, January 16th, even before the CMS letter was delivered on January 31st, correct?
That's correct. This is dated January 16, 2019.
And it's addressed primarily, or at least first, to Mr. Sowers, the interim CEO.
Correct.
All right, and then she attaches, let's go to page 2 of this, please. She attaches the hospital's anticipation of what's coming and how they're going to rectify the situation. So let's go to page 3. And we've seen these terms in, let's say, federal regulatory agency speak, but here they are in the hospital's words. So we're just looking at the focus area of governance and the 2 primary findings there. Would you speak to those? Let's start with over-reliance on department-level case review. Would you please explain what that means?
Right. So recall that the Department of Pediatrics had 15, and at this time, I believe they had actually 20 divisions reporting up to it. So the Department of Pediatrics, which is pediatric medicine, managed 15 to 20 different divisions, and then the Department of Pediatric Surgery managed all the surgical subspecialties. And so they in this governance structure, they created parallel systems for quality assurance and performance improvement. And so, again, they were kind of left to police themselves.
And the second one there, issues did not flow freely to the board. You've spoken about that a little bit earlier. Is there anything to add?
No, again, if the board is accountable. If something goes wrong, the board has its feet held to the fire. But as we've seen elsewhere, if the information is not flowing in and they're not able to pull the information up, they can't do their jobs.
And then we get to the second focus area, which is culture. And it references the fear of retribution, was speaking of that you mentioned earlier.
Yes, sir.
How does hospital culture manifest at the patient level?
So,
Overruled.
so culture starts at the top, and one of the elements of just culture, which is actually a formal program, one of the elements is that you really want to think about what's best for patients, and it acknowledges that mistakes can be made, and it tries to differentiate between I made a mistake or I knew it was wrong and I did it anyway. The focus on culture as the patient sees it, that's really the patient experience. Are my needs being met? Do I feel like I'm being listened to? Are people?
No, no, no. No, no, no. She did not feel listened to. Her needs were not being met. They wouldn't even bring her to the bathroom. This is damaging, you guys. And the jury is hearing all of this, remember. We jump around so much, it's hard to remember when the jury's in the room and when they're not, and when the proffer's happening and when the jury's there. Jury's hearing all of this. If you're sitting on the jury right now, what are you thinking? Are you thinking it's as bad as I'm thinking it is?
Advocating for me. You know, Maya was 10 years old and celebrated her 11th birthday at the hospital.
Let me interrupt you for a question
Please.
before I get an objection.
Sure.
You mentioned an advocate. What is the concept of a patient advocate within a hospital?
Well, a patient advocate is somebody who is keeping an eye on all the moving parts. You know, there's a lot of focus on what the doctors do, appropriately, but there's an awful lot of people that have to do their jobs well if that care is going to hit the target. And so an advocate is someone who is kind of watching all the inbound aircraft and making sure that they're aligned for what's best for the patient.
Is it true that a patient advocate would be someone that would be present with the child over the course of their admission?
Not side by side. I'm sorry, Judge.
I'm going to sustain the reading.
Have you observed the different, and had an opportunity to watch the testimony of the different witnesses that the defense presented here?
Many of them, yes, sir.
Did at any point you see someone who claimed to be the patient advocate for Maya Kowalski?
Objection, Your Honor. Relevance calls for conclusion. Calls for argument.
Overruled.
Somewhat surprisingly, no. We heard a lot from members of the teams, the medical team, the social work team, the risk management team, and there was a lot of team management talked about in how Maya's care was delivered. But I don't recall hearing from anyone that was really playing guardian angel, somebody who was really looking out for Maya and her care.
If we could advance to page 5.
Wow. Guardian angel. I wonder if the jury's thinking maybe that's why Beata did what she did, so that she could be Maya's guardian angel.
And this is the last one we'll speak to in this hospital presentation. Disclosure and communication with families. And then it says inconsistent practice and documentation after adverse events. Would you please explain this concept in the context of hospital management and the importance of communication with families?
Objection calls for argument and for a narrative.
Overruled. Yeah.
Thank you. So I tell my doctors and my team, when I was in the role, I told my doctors and my teams, if you make a mistake, own it, just like I tell my kids. So disclosing, hey, we made a mistake, is considered an important first step in communication and regaining trust that can very easily be lost if a mistake is made or if an outcome is not what everybody intended to get. So inconsistent practice means that there was no endorsed or encouraged best practice for all of the divisions and ultimately the departments to follow.
Through your observation of the testimony here, including that of Dr. Jennifer Katzenstein, has it come to your attention that Jack and Beata Kowalski attempted to communicate their concerns with the hospital?
Objection, Your Honor. Bates province of jury calling for editorial comment on the testimony.
You
Wow.
can take that down. Based upon your background training experience and to reasonable management probability, do you believe that the deficiencies that we've discussed here caused or contributed to the patient experience and the harm done to Maya Kowalski?
Objection, foundation.
Overruled.
Without question, the gaps in the function of the governing body, again, Dr. Sowers said it was a contributing factor in previous lapses. I have no reason to counter that opinion. It's undoubtedly true that they contributed.
All right, nothing further to say.
Undoubtedly true that they contributed. That is his expert opinion based on his expertise in the area of hospital policies, procedures, and protocol. I have never, I'm going to say never. I don't think I've ever seen a witness as well-spoken, as readily available, as educated, as kind, as good on the stand. This is the first time he's ever testified in a case, you guys. First time he's ever testified in any case. Mark my words, his expert witness business is going to boom after this. Every plaintiff in the country with a medical malpractice case, a big one, is going to hire him, is going to want to hire him to be on their side. 100%. And he's pro bono, by the way. Hasn't he testified he's not even charging the plaintiff? There should be more guys like him out there. So, Christine, if you're here, your niece is a very lucky girl to be married to him. And do you remember the first time that he came on the stand? How kind he was about his wife and his family? And the nice things that he said about them, and how he gave up his job on the other side of the country because he wanted to be with his kids and his wife. So kind. Let's see what Hunter can do. Okay. Let's just take a minute. Let's just take a minute and thank some people so much. Oh, Seashell became a new member. Thanks for becoming a member. You're really going to like it here. And Julie DeWalt, thank you. In Love with Law, thank you for your super chat. If Maya's health would allow it, I would love to see her on Dancing with the Stars. Oh my God. Oh my God, I didn't even think of that. In Love with Law became a, thank you for becoming a member in Love with Law. And Teresa, thank you. Oh, Mystique, it's really good to see you. I know you're here a lot. Oh, there's a fly. Thank you for the super chat. I'm loving your channel. I just want to say thank you for covering this case. Team Maya, yes. In case you haven't noticed, we have Team Maya merch. All proceeds are going to CRPS research. So I didn't jack the prices up a lot. So whatever profits I make off of them, I am going to donate them to CRPS research. If you have any ideas for foundations or charities or that do CRPS research that you know are reputable, please let me know. I'm open to suggestions. You can always email me at fanbase@mlittlelaw.com. Thank you, Mama T, for becoming a member. I think you're going to like it here. Joan Summer, thank you so much for your super sticker. Hi, Beach Lover. I'm good to see you. I hope you're feeling good today. Brian Cox to play Hunter. Yeah, from Succession. You know, when I did that poll, it only gave me like 5 options. And I tried to put him, 4 options. I couldn't. And the poll is very close, you guys, as to who should play Hunter. John Lithgow is in the lead, surprisingly, at 35%, Kevin Spacey at 26%, Kiefer Sutherland at 25%, and Mel Gibson at 14%. All right, so I will note those down, and I'm going to start the next poll coming up soon of who should play Dr. Corcoran. That's going to be my next casting job, so I'm going to go there next. I already have 4 choices, and we will see. Stephanie. Oh, hi, Tara. Thank you. Jack saved juror after the defense shows jazz hands. Yeah. Yes. Yes. Yeah. You think that's it? I think you're right. Thank you for your super chat. Hey, Paul. Thanks for your super chat. You have a memory like a steel trap. I don't know what it was that I remembered, but I don't know. My kids might disagree with you. They're like, I told you about this last week. I'm like, I have no idea. What are we talking about? Where are you going? KBF, thank you for your super chat. He's fighting to hide that document, but all the other plaintiffs' lawyers know it exists. Wormtail from Harry Potter should play Hunter. Thank you to James for being a member and all about the shade. And Lisa Wilson, thank you for your super sticker. I appreciate all you guys. Marsha, all double speak from the defense. Yes, I agree with you. Thank you for your super sticker, super chat. KBF Hunter continuing to pile on top of lie is why I would have fought and died on the hill of striking their answer, KBF. Yeah, thank you for that super chat. I think you have a good point there. And Jermaine, yeah, this is, I went backwards up the chain here, but yeah, Hunter was not as cocky this AM. No, he wasn't. That's why I thought it was so interesting to play the juror motion first and then go back to the morning because he was a little in his shell a little bit, right? Thank you, Jermaine, for the super chat. And I think I got them all for now. And let's go back and see the cross of this. And I'll put up the new poll. All right. Let's
It's not me.
Good afternoon,
Good
Dr.
afternoon,
Corcoran.
sir.
You were provided a number of documents regarding various surveys, correct?
I saw several documents that involved surveys. Yes, sir.
Were you given a set of documents regarding a joint commission triennial survey from September of 2015?
I saw the summary of it. Yes, sir.
That resulted in the joint commission accrediting the hospital, did it not?
In 2015. Yes, sir.
And that accreditation was good for the following 3 years unless it was revoked,
That's
correct?
correct.
And did you also see a survey? And incidentally, these surveys are fairly arduous events, are they not?
Typically, you've got 3, 4, maybe 5 surveyors on site for 3, 4, or 5 days. Yes, sir.
When you were at Brandon Regional Hospital, did you handle those?
I was absolutely involved in every day that they were on site.
Very searching review, correct?
They were stressful. Yes, sir.
All right. They went to all aspects of the hospital, correct?
They did.
So when they did that at Johns Hopkins All Children's Hospital in September of 2015, they reaccredited the hospital, correct?
Yes, sir.
And then in 2016, they did a follow-up random review. You saw that, didn't you?
I don't. Could you refresh my recollection on that, sir?
Sure. Wasn't there in March of 2016 a follow-up review of evidence of compliance with the accreditation they had been granted the year before in March of 2016?
If you're gonna refresh his recollection, why don't you show him the document?
Let me get that pulled up, Judge. Let me ask a couple questions first before I do that.
Hmm.
Here you go.
I have a request to
Hey,
slow it down. So
you were present
I can't slow it
During
down
Ms.
all
Green's
the way
deposition
because
the other night, right?
I was
it
there.
really
Yes, sir.
drags.
you
All right,
provided
it's too slow. Hold on.
A
Okay,
copy.
Time out. Time out. Time out.
Deposition the other night, right?
I was.
You were present during Ms. Green's deposition the other night, right?
I was there. Yes, sir.
And were you provided a copy of the review done by the Joint Commission in March of 2016?
Mr. Hunter, I can't say with certainty that I was. It was Parents' Weekend at my son's college, and I was up in Gainesville. So I played dad instead of expert witness this weekend. I can't tell you which documents off the top of my head, which documents I saw and which I did not.
Right, Mr. Hunter, because I'm not getting paid by the hour like you are to work all weekend. I have a life too.
I certainly did not see but a small fraction of what was turned over.
Well, did you see a risk management survey that was done by ACA in February of 2017?
Again, I'd like to have my recollection refreshed. I don't recall which ones I've seen and which I didn't see.
Did you
Just-
see?
Just hand him the document if you.
Judge, I'm sorry that there's a stack of documents that would gag 3 billy goats and a maggot about this tall.
I don't understand.
Okay, what did he just say? Something about a maggot? What? First of all, you should have your papers in order. And the reason that there's so many papers is because that's how many you didn't turn over. And you knew exactly what you were going to cross him on. And you knew exactly what documents you wanted to use. So the fact that you don't have them there is a little hard to believe.
Did you see?
Just hand him the document if you.
Judge, I'm sorry that there's a stack of documents that would gag 3 billy goats and a maggot about this tall.
A stack of documents that would gag 3 billy goats and a maggot. I've heard a lot of expressions in my time. A lot. I use a lot of them too, but I have never heard something that would gag 3 billy goats and a maggot. Can anybody tell me what the origin of that expression is? I'm going to have to Google it. Is it something that is said in a certain part of the country? In the Florida Panhandle? I don't know. Help me here. If anybody knows, if you've ever heard that before, I got a stack of papers here that could gag 3 billy goats and a maggot. All right.
Understand what that means.
Well, it's a lot of documents.
And I don't have at my fingertips the ability to grab that particular document. I had a,
Do we need to take a few minutes
Mhm.
so you can organize?
We'll give you
it
all the
would be
time
very
you need.
helpful, Your Honor.
Why don't we take 5 minutes? Members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Oh. A little salty, huh? A little salty. I'll fast forward while you guys tell me what you're thinking. If anybody knows about that 3 billy goats and a maggot, please let me know. Because I never heard nothing like that before, sir. We don't talk like that around here. Mhm. Yeah, right. Exactly. Exactly. Totally backfired on him. Like, really? You don't have, I can't believe you don't have your exhibits at the ready, sir. Counselor. Certain, no, it's not a northern saying. Oh, Ed, you want to write yourself in for Dr. Corcoran? All right. All right. Yeah, but can you not sweat on the stand like that? No, not Australian. Recovery addict. Oh, now he's in the attic, huh? No, not from Oregon. Gag a maggot. 3 goats and a maggot, he said. 3 billy goats. 3 billy goats and a maggot. Well, where do billy goats reside? Doo, 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 doo.
Was affirmed.
Objection, counsel testify.
Objection. Hold on, they're at the back.
As a result, you
Got it. But before we go there, let's see if anybody can figure out about the billy goats and a maggot. And also, before we go there, and since Ed is in the chat, anybody know what a Funko Pop is? Anybody know what a Funko Pop is? Well, I got a Funko Pop. Look what someone sent me. See? And she has a little cupcake in her hand. Isn't that the cutest thing? So what a great gift idea. You can have a Funko Pop and have it made like someone. Everyone thank Ed in the chat for sending this to me. Isn't that the cutest gift ever? And I think she's supposed to stay in the case, so I didn't unbox her yet. It's not really an unboxing, but it's a like, look how cool that is. Ta-da! Okay. All right. And moving on. Thanks, Ed. Okay, let's see. Here we go. And we're gonna see if Mr. Hunter can get himself off of the hot seat. What say you? What's the over-under on this? Maybe instead of polls, we should start like putting money down. Like, I know Recovery Addict has a thing in his chat about how many objections there are for the entire entire trial. I don't know what you're going to win if you get the number of objections correct, but I think we're up to like what 1,700 and something ending today. Recovery Addict, if you're still here, tell us what the over and under is on that. And there will definitely be some objections during closing. So if you're close in his contest, don't think that there won't be objections during closing, because you know some of these attorneys can't keep their mouths shut, quite frankly. It is rude to object in closing because pretty much it's your argument and you can kind of say whatever you want at this point, unless you're totally mischaracterizing what the evidence showed. But that is what I think. So I don't know what his prize is. It's at 1771. Is that what you think? 1773. You win a hoodie. Okay. All right. I'm gonna have a contest. I can't decide what it should be yet, but we'll get there. All right. Somebody asked if we are watching today's trial. Yes, we are. We are still watching. This is Dr. Corcoran's cross. We already did the motion to dismiss juror number 1. We did the other incident at the end of the day where another juror was excused because he had a medical issue. And we did the beginning of the day with the scrambling and the Holy crap, I think I might just lose my job or my law license on behalf of an attorney. But here we go. Back to Corcoran.
Mr. Hunter,
Yes, Your Honor. May I have first witness?
you may.
Dr. Corcoran, I've got a accreditation report here from March of 2016. Have you ever seen that before?
I don't believe so.
So you've never reviewed what I just showed?
I don't believe I've seen this particular report.
Yeah, I know we approached for a moment.
Sure.
I'm riding the Swifty train too, Matt. Totally. I am. We are Swifties in this house.
You got to see as a result of that on Friday night.
I-
Provide us. So the jury's aware you were provided us a number of documents, or you attended a deposition Friday night.
I did.
Okay. There are a number of documents that you got to see as a result of that, correct?
Yes, sir.
Okay. The one I just showed you, you said you'd never seen before.
I don't recognize it. It may have been introduced, but I don't recognize it.
Well, my question to you is, do you have any reason to question the proposition that in March and April of 2016, a joint commission survey occurred unannounced at All Children's Hospital and their accreditation was affirmed?
Objection, counsel testifying.
Overruled. You can answer.
I'm sorry. Can you repeat this question, please?
Yes, sir. Do you have any reason to question that in March of 2016, followed up in April of 2016, a joint commission survey took place at Johns Hopkins All Children's Hospital and that their accreditation was affirmed?
Yeah, I have every reason not to believe it because you're the one telling it to me.
So I have no reason to question you. And that if accreditation was renewed in 2015, then unless there were a flagrant violation, accreditation would not really be on the table at that time.
Well, wouldn't there be occasional random follow-ups to accreditation inspections?
Short answer, no. Most of the time, Joint Commission returns to a facility in response to a complaint or awareness of some kind of a problem.
So you've never heard in your long experience of random surveys taking place after an accreditation in the preceding years?
Objection, argumentative.
Overruled.
There can be follow-up surveys. When the accreditation survey is done, then CMS actually audits the work of the Joint Commission and will come in and do, I'm blanking on the term for it, but they will basically come in and affirm that the Joint Commission survey is accurate.
Okay. The document I just showed you was a joint commission survey, correct?
I believe so, yes, sir.
And you have no reason to question that it affirmed the accreditation.
Well, I don't think that was in the time frame. Typically, CMS comes back in 45 days or less. So I don't think that's the kind of survey that I was referring to, sir.
All right. Well, let's go with this another way.
May I, if you'll show me the document, I'm happy to do a quick review of it.
Well, I'll be happy to show you this and the two subsequent follow-ups from these complaints.
He needs himself a Mr. Reyes to get him his documents together, get his stuff in order before he gets up there. That would have been a great, Linda Capra, that would have been a great poll. How many times Hunter insulted the judge or just insulted our intelligence as the general public watching this trial?
Just the three, or is that it?
This is a different one.
Okay. Can you give me a minute to look at them?
Sure.
Okay.
Perhaps, Mr. Hunter, you could return to the lectern.
Perhaps, Mr. Hunter, you could get the hell away from this witness instead of standing over him, towering over him. I don't know. I don't know how tall he is. Who's in the courtroom today? Somebody's in the courtroom today. Tell me how tall Hunter is. He's no Rex Sherman, I'll tell you that. He's no ogre. He's no 6'4" ogre. Thank you, making law simple. Thank you very much for your very generous super chat. And yeah, I can they take the camera off Maya and show the people actually talking, or is that too appropriate? Yeah, I don't know why they're doing this. I don't know why they're allowing this. I don't know if there's a pool camera in the courtroom that is sharing the feed with Law and Crime, if they have their own camera. This is why in the Koberger case, the judge has said that he is going to allow cameras, but he is going to control the cameras, because we've seen that in Koberger too. They have a camera in the courtroom. It's showing the side of his head or the back of his head the entire time, instead of the actual attorneys that are making the arguments. Thank you for that. Georgina, you don't have to play. You don't have to pay anything. We're happy you're here. Don't be silly. It's free. It's free to participate. Somebody said the other day in the stream, I'm gray, so she's not answering my question. You guys, you don't understand how fast this chat is moving, and I'm on StreamYard, so it doesn't, like, even if you highlight my name, I can't see it on StreamYard because it's all the same color. So it has nothing to do with whether I'll answer your questions or not. Please don't feel that way. Nobody's required to pay anything to be here and be welcome here. This is a very friendly place, so please do not feel that way. It costs you nothing to subscribe and hit a like button and to participate. So by no means should you in any way feel obligated to donate a dime or buy a shirt or anything. Your presence is my present. How's that?
So,
And this is not about likes and clicks and views for me. This isn't. This is about getting important information out there and getting important topics out there and talking about important topics. And there are a lot of shows that I do that get demonetized, and I don't care. I'm talking about it anyway. I'm going to talk about the fact that Matthew Perry turned his life around. And I'm going to talk about how hard it is to love an alcoholic or an addict. And that was an entire show that I did between Matthew Perry and people who love addicts and alcoholics. That was demonetized immediately, but it's important and I want to talk about it. The only problem is that the algorithm doesn't get the show out there, so nobody sees it. So if you haven't heard of me, that's why, because I don't play by the rules. Somebody was kind enough to send me a spreadsheet of all of the demonetization words, and it's crazy. The reason, and then I found out 2 of those words were in my title of my Matthew Perry stream: addiction and alcoholic. So forget about it. I had no shot, even after a human review. And you know what? I don't care.
on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to utilization of moderate or deep sedation or anesthesia.
And were there, excuse me, were there indications of a follow-up that established compliance?
I'm looking for that in the next visit, sir. You want to match up the ECLD. So this visit that was approximately a month later is a survey addressing different elements of participation, different standards.
And it indicated compliance.
He's like, give me a second, dude. Give me a minute.
This shows compliance. This still has some outstanding issues.
Mm-hmm.
And there's a subsequent that shows that was placed in compliance, correct?
Piece it 1 second, sir. So this survey dated 4/22, which is the 45-day evidence of standards compliance, does show compliance with the anesthesia related fallout, but not the leadership one. And this one dated May 3, the 60-day visit, does show 040, LD 040105 is now compliant. So from March until May, they had issues and they corrected them.
And that's fairly typical of Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
Oh, really? Now he's going to, first of all, as a lawyer, never ask a question you don't know the answer to, ever, ever. It's like trial law 101. And now he's going to try and turn it around and say, well, your hospital had all of these also had all of these problems too, didn't it? He's here as an expert witness. Good luck with that. It's going to go over like a lead balloon.
And incidentally, there's a number of ACA inspections of typical of Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
And incidentally, there's a number of ACA inspections of your hospital, correct?
ACA is a frequent visitor to most hospitals, sir.
Frequent visitor to Brandon Hospital, correct? For complaints and otherwise.
I will tell you, during my tenure, they were frequent but not overwhelming.
Now, isn't it also true, sir? Well, let me just ask it this way. You were given a report of an unannounced accreditation survey by the Joint Commission of Johns Hopkins All Children's Hospital in August of 2018.
Unannounced in August of 18, wasn't that when they had their re-accreditation visit?
Yes, sir. Yes, sir.
And there was a second visit
Yes, sir.
the same month?
Yes, sir.
I don't believe I saw that one.
Okay. But those visits resulted in reaccreditation, did they not?
Not the second visit. That's not a reaccreditation. They were reaccredited in August of 18.
Okay.
But that was their triennial review. Yes,
Okay.
sir.
So the point I'm making here is that in August of 2018, there was a triennial reaccreditation survey done by the
Right.
Joint Commission that resulted in reaccreditation, correct?
Right. And all of the violations were on the safer matrix in the lower, less frequent quadrant.
That's where you want them, right?
Amen.
So in August of 2018, the 3-year accreditation that was issued in September of 2015 was continued, correct?
Somewhat surprisingly, yes.
All right. Well, editorial comment aside, it was continued, correct?
Well, again, given the presence of ACA joint CMS starting in April of that year, yes, they got away with a remarkably benign evaluation.
Okay.
And it was, in fact,
And it indicates
reaccredited.
effort on their part to do that, correct?
Okay.
Remarkably benign.
Incidentally, were you provided information regarding a CMS survey of all children's in May of 2017?
Again, can you show me the document? So I
Sure,
can
I'm showing the
refresh?
witness trial exhibit 2823-001, marked by plaintiff.
Yes, this was a visit specific to the pharmacy.
Showed compliance, correct?
I believe there were no issues identified on that visit.
Okay. Now, let's talk for a minute, if we could, about some of the reports that council walked you through. Let me first have direct your attention to trial exhibit 2811. You can put that up, please. I'm not sure we need to see the details of it. But was there any indication in that report, and you reviewed this, right?
I did this
Okay.
today.
Okay.
Yes, sir.
You testified about this a few minutes ago.
I did.
For counsel.
Yes, sir.
Okay, so were you aware of any joint commission survey of the hospital being done at the same time or around the same time as this particular report?
I'm struggling to answer clearly because there were so many surveys. Candidly, Mr. Hunter, keeping ACA from CMS is a challenge given the short timeline and my cursory review of just a part of the documents that you shared.
Let me show you what I'll represent to you as a joint commission correspondence to Mr. Sowers dated February 25th, 2019. We ever shown that?
Yes, this is a letter that documents the acceptance of the conditions of, the plan for corrective action from the IP. Is that correct?
I believe you'll see
From the
that-
IJ, sorry, the immediate jeopardy.
I believe you'll see that that indicates that there was a survey done by joint commission at or about that time that resulted in a finding of compliance.
I love how we
Yes,
really
the services at your hospital were found to be in substantial compliance.
That was a joint commission survey that occurred, correct?
And that was done 1 month after, or 23 days actually, after the IJ. And 23 days is kind of that magic window that if you're not in compliance by then, you are at risk for losing your funding.
I'm glad you brought that up. So the IJ was issued by CMS, correct?
Correct,
All right. This is the joint commission.
right?
They're not the same thing.
They're not.
Okay. So the joint commission found that there was substantial compliance. And the CMS was in the process of following up on the IJ, correct?
So it gets even stickier because the CMS surveys are typically handled by ACA surveyors.
Okay. Well, whoever was doing that, they lifted the IJ at about this time, February 25th, did they not?
They lifted no. What they did at that time was that they accepted the corrective action plan. The IJ threat was still in place until I believe late May or mid-June of that year. And in fact, the hospital requested and was given 2 extensions to comply. And then ultimately had signed an agreement, a binding agreement with the federal government that it would accept having a consultant in the facility for the next 12 months who would oversee or direct the compliance. And in exchange, the federal government takes the threat of losing funding away.
But the IJ was lifted.
Again, they accepted the plan of correction.
Correct. And lifted the IJ as a result, correct?
No, sir, because again, they were still under threat of being removed from funding until late May or early June.
But at that point, the IJ was ultimately lifted, correct?
At the end of June, yes. I'm sorry. I thought you were asking about that February date.
All right. So we can agree the IJ was lifted.
With an asterisk because of these
And we
extraordinary.
can agree that there was substantial effort put forth at compliance.
let him
Oh,
finish his
absolutely.
answer.
All right.
The new team actually did well.
Okay.
They were.
Let him finish his answer because now he's going to say something good about your new team.
there was substantial effort put forth at compliance.
Oh, absolutely.
All right.
The new team actually did well.
Okay.
They worked hard.
Well, let me come back to that in a minute.
He doesn't even want to agree with it.
Uh,
Well,
in this 2811, where is the reference to nursing service?
This survey was conducted in conjunction with a risk management survey.
That's all, just risk management.
From what you're showing me, yes, this is a risk management survey.
All right. Where is the reference to risk management activities in the fall of 2016?
There's nothing specifically mentioned about 2016 in this unannounced complaint investigation.
Now, there was talk about trial exhibit 2815. Let me ask you, get that up if you could, Clay. And you talked about 4 areas that it addressed. And this is the announcement of the IJ in January of 2019, correct?
January 31, 2019. Yes, sir.
Okay, and that's January of 2019 is about 2 years after Maya Kowalski was discharged, correct?
That's correct.
All right. Now, in this statement of the grounds and the findings that are based on the IJ, that were the basis for the IJ, where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
he knows exactly where to find it. Exactly where to find it. And Hunter wanted him to say, oh, it's not here, because that's what his witness would have said. He knows exactly where it is.
By all means, do you have that handy?
No, sir.
By all means, do you have that handy, Dr. Corcoran? Really? No, Mr. Hunter. It's in the 3 boxes of materials that you gave us over the weekend. Wow.
Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff,
Medical staff in general,
right?
no specification to the hospitalist service.
Not in this letter. Again, this is the overview, not the detail.
Okay, so the detail is in the 11119 form
2567.
2567 in the lower left-hand corner.
Yes, sir.
Okay. So you looked at all 100 and some odd pages of it?
We could ask Christine this question, Green Eyed Southern Girl, but I'll fight you for him if he does.
I did not see the version with the corrective action plan. I looked at the original document, which was 49 pages.
Okay. And I may have that in my hand too. I just can't tell the weight of these things.
Fair enough.
But I was curious, in looking at this document, did you see any specific reference to the PICU intensivist service?
The intensivist physicians were not specifically mentioned. No, sir.
Nor were the hospitalists, correct?
To my knowledge, no, sir.
All right. And you didn't see any reference to the pain management service either, did you?
No, but again, the issues that were cited are the ones that support them and also oversee them.
They
Right.
oversee them, but we're talking about themselves, the people,
Yeah, and it's
not the structure
unusual.
of the people.
I understand your question now. It's unusual for specific physicians or specific medical groups to be identified in these kind of surveys.
And in that survey, did you see any reference to what was happening on the 7th floor, the medical surgical unit, in October of 2016?
Well, again, no, because the survey is not geared to follow specific physician groups and their individual practices. That's a job that falls to the medical staff led by the MEC. And that's what was called out here. So more.
Well, there's specific examples given for most of these things.
You can keep trying to rephrase that question. You can keep trying to ask it a different way. You can keep trying to ask it in a way that requires a yes or no response. He's never going to give it to you, Hunter. He's never going to give it to you. So just let it go. Sit down. You are doing yourself no favors. Doing yourself no favors. He's too smart. Some witnesses you can control and some witnesses you can't. He is not going to get you to say, he's not going to say what you want him to say. He's just not. He's too honest. And he has no points to prove. He's just telling the truth. So sit down.
And so what I'm trying to find out is, did you see in this report, in the original report that put in place the IJ, or was the basis for what was put in place as the IJ, did you see any reference to the events of October, November, and December of 2016?
Specific to those dates, no, sir.
And you saw no reference to the psychology service specifically, did you?
That's correct.
And you saw no reference to the psychiatry service, did you?
For those dates, no, sir, you're correct.
Now, there was reference to your discussion of trial exhibit 2817. A, excuse me. See, she does it to me too. It sounded to me like you were saying that the problem, or one of the problems addressed
Can you
here
put that
was-
document up, sir?
Oh, sure.
Nothing's getting by him. You can try.
I just got a couple of questions about it.
Sure.
Good. Put it up so we can look at it.
First of all, it indicated they were working to improve the situation, right?
Yes.
Okay. And in some of the documents you made that we were referenced here, specifically 2821A, you weren't asked about that one.
I don't recognize it by number.
2821A in evidence. You can put that up. Well, let me finish. It's too quick for me. Let me just ask you first of all before we.
Sorry, guys, I can't even read this for you. It's too blurry. I know that some of you think it's blurry and you can't read it, but I can't read it either. So it's not you.
It's 2817.
Yeah.
It sounded to me like what you were concerned about in this document was the extent to which risk management was not reporting upward.
That was one of the talking points that they developed for the interim CEO to address with the board.
And they were trying to.
Was sharing of information, correct?
Okay. So information wasn't getting shared by risk management. Right?
That's the inference from their
Okay.
talking points.
All right. So let's go back, if we could, to what I was referring to a moment ago, 2821. This is a letter dated 10 February 2019
Yes, that's true, cat lady.
regarding the statement of deficiencies.
I got to speed this up a little.
Right.
He's making me fall asleep.
Yes, sir.
Okay. And this letter indicates, does it not, that efforts to address what later became the basis for the IJ had already begun by the time of the inspection, correct?
That's incorrect. This is February 10 of 2019. The survey was 10 days earlier. This is the response to it.
Understood. This is the response to the inspection report from January 11th to January 7th to
7
January
to
11th.
11.
And this was one time submitted within 10 days, correct?
From the January 31 report back. Yes,
Right.
sir.
And this letter summarized efforts that were being made to address the IJ concerns, correct?
It does. And as I said, the new team actually worked really hard. It was
Right.
too late to help Maya, but this was
Well,
good work.
Too late to help Maya.
The new team was already in place by the time of the inspection, correct?
Oh my God,
They-
really? You're going to try and unring that bell, Hunter, by just asking another question? Like, as if the jury didn't just hear that? Wow. Pivot, pivot, pivot. Hold on, I got to play that back. Step, kick, kick.
This letter summarized efforts that were being made to address the IJ concerns, correct?
It does. And as I said, the new team actually worked really hard. It was too late to help Maya, but this was good
Well,
work.
The new team was already in place by the time of the inspection, correct?
They were assembling. I think Ms. Green actually took her role 3 or 4 days before 12 inspectors, surveyors arrived. But yes, sir, they were assembling. They were
The executive-
mustering.
But the executive team was already in place and already addressing these concerns by the time the inspection team arrived, correct?
I can't speak to the entire team. They had 8 departures in leadership, so I don't know that all 8 spots were backfilled. But I do know that there was an interim CEO in place. Regarding the other 7 positions, I have no idea when they
And
were
you've shown
filled.
us his talking points and the efforts that were being made to address the situation, correct?
Following the survey, yes, sir. And he was also one of the, per Ms. Green, he was also one of the attendees at the visits to CMS in Atlanta and ACA in Tallahassee.
Mm-hmm.
They have a moment, Your Honor.
You may.
Oh, he needs a moment. Now he needs a moment because he's just trying to get in there for the final blow.
You didn't, we lost.
All right,
That's,
gonna work, but no,
well, we
in front of the jury. Since your weekend plans are now in front of the jury, you went to the Florida football game on Saturday.
you didn't have to remind me, sir.
I thought the black uniforms were gonna work, but no.
Well, we lost.
All right,
That's all I'd like to say about it, sir.
sure. And you spent Friday night with me and Mr. Hunter at a deposition of Ms. Green.
I did.
And how long did that last?
We sat down at about 4 o'clock. I want to say we left the building somewhere 7:30, 7:45.
Before that deposition, had you ever seen the first corrective action plan from Johns Hopkins Ultra Hospital?
Not to my knowledge, no.
And just so that your diligence is not in question, first of all, we left with a stack of papers, did we not?
A box full, yes.
Your Honor, relevance beyond scope.
Overruled.
We left with a box
Overruled.
full of papers.
Yes, sir.
And you did not spend your weekend reviewing everything that was provided on Friday night, did you?
No, sir. As I said, I was a dad this weekend.
And then 2 more boxes were provided to us over the weekend.
That's what you told me. Yes, sir.
So the fact that you haven't seen a particular survey is not a reflection of your diligence, is it?
I hope not.
Okay. Now let's talk about surveys. That's what they are, right? A
They are.
survey.
They are.
And these folks that come from whether it's the Joint Commission or CMS or ACA, they're in their hospital for what, a week?
They can be there. Typically, they run 3, 4, or 5 days. Now, a complaint survey can be in and out in a matter of hours or a day. But when they're full surveys, there are multiple days with multiple surveyors. And typically what they'll do is for an accreditation survey, for instance, they will bring an engineer to look at the heating and cooling, to look at all the mechanicals of the elevators. They'll bring nurses in to look at nursing things. They'll bring in pharmacists to look at pharmacy things.
The short answer is they're there for a brief period of time in any hospital during a
It
survey.
feels like forever, but they're typically there for 3, 4, or 5 days.
All right.
And with the CMS survey that was done January 7th through the 11th of 2019, my understanding is that there were 12 surveyors.
In the intervening 3 years between an accreditation or reaccreditation, the Joint Commission folks or the CMS folks or the ACA folks, they don't live at the hospital. They don't reside at the hospital. They're not there every day, right?
You try to keep them at bay.
The system, as it is reliant on self-reporting, is it not?
It's encouraged for sure.
It's reliant on the hospital that's being evaluated being an honest actor.
Correct. And there are some specific fallouts that require timely notice. For instance, an adverse event, requires a code 15 filing if it's severe enough. And so that needs to be, Tallahassee needs to be notified ASAP.
And in this instance, was it discovered that Johns Hopkins All Children's Hospital was not self-reporting adverse events in a timely fashion?
I'm going to sustain that one.
Understood. This was all the genesis of an eventual self-report by Johns Hopkins All Children's Hospital, right?
Objection leading, Your Honor.
Overruled.
The survey that ultimately led to the IJ, which was backdated to 4 or 5 months earlier, did involve self-reporting.
What drove that self-reporting?
Objection, Your Honor. False speculation by the witness.
Overruled.
Yeah, Yeah.
There were
here it is.
several issues at the hospital that were well documented by local press that actually ended up being a finalist for the Pulitzer Prize for investigative journalism.
Objection, Your Honor. Move to strike.
Pulitzer Prize for investigative journalism. That's why they self-reported, because the Tampa Bay Times, I think that's the paper, right, you guys, was onto them. They were snooping around for the scoop. That's why they self-reported. Let's rewind that back because that's a win. We got to hear that one more time. He just snuck it right on in there with such finesse. That was really beautiful. Really beautiful. I'm verklempt a little bit.
Well documented by local press.
What drove that self-reporting?
5 months survey that ultimately led to the IJ, which was backdated to 4 or 5 months earlier, did involve self-reporting.
What drove that self-reporting?
Objection, Your Honor. False speculation by the witness.
Overruled.
There were several issues at the hospital that were well documented by local press that actually ended up being a finalist for the Pulitzer Prize for investigative journalism.
Objection, Your Honor. Move to strike, not responsive.
The jury's going to disregard the comment about the Pulitzer Prize.
It's all right.
Sorry, Your Honor.
Can we approach, Your Honor?
I'm done with that line of questioning.
That was great, wasn't it?
Having observed the trial here, have you seen or heard any testimony from anyone with the title of vice president or above from the hospital to explain that they had this all under control during 2016 and 2017?
Objection, Your Honor. May we approach?
Sure.
May we approach? I need a little extra time to figure out what I'm going to do and say and how I'm going to sort of get out of this.
Anything further, Mr. Hunter?
Your Honor.
Members of the jury, do any of you have any questions?
Yes, BH, you're right. Although I think he did move his doctor's appointment. BH says he was trying to make Mr. Corcoran late for his doctor's appointment. He needed to leave at 2. He got finished at 1:55. Villa Ray, I know that you said you were in the courtroom today. If you want to come in the stream, you don't have to turn your camera on. You can just come on by phone. You just need to be in front of a computer or a phone, and I can send you the link, and you can come in and talk to us if you would like to. No pressure. Would anybody like to hear from Villa Ray, who was in the courtroom today? I know you guys probably heard from Jules, but it's a different set of eyes and ears.
And all the corrective actions that were 2019.
Questions, then Mr. Hunter will have an opportunity to follow up. Was posed, but Mr. Whitney will ask questions, then Mr. Hunter will have an opportunity to follow up. Question that was posed, but Mr. Whitney will ask questions, then Mr. Hunter will have an opportunity to follow up.
The 2019 immediate jeopardy finding and all the corrective actions that were performed by Johns Hopkins All Children's Hospital. Is it a fair, well, first of all, there was a retrospective analysis that led to this. Is that right?
Objection, Your Honor. He's leading.
Overruled.
Right. So, yes, they look at what led to the problems. If you think about it as a firefighter shows up, puts out the fire, but looks at whether the electric panel has any issues, whether there's carpet in front of the a portable heater. They look for the causes of what allowed the problems just to show up.
And is it accurate summarization of your testimony to say that the issues that, as they're contained in that dense federal document, surfaced as early as 2015 within the hospital?
Yes.
Objection, leading, Your Honor, and also argumentative.
Overruled on both.
Yes, there were 4 or 5 pediatric cardiac surgery.
I'm going to remind you of the instruction.
Sorry. There were 4 or 5 PAs in the operating room who had concerns.
Objection, Your Honor.
Let's not.
Let me ask the
go into
question.
details.
Let me ask
Okay.
another question.
The
Let me ask
Remember the guardrails, Dr. Corcoran. He likes to use that term, guardrails.
the question. Sorry. We're testing you. Were there self-reports at the employee level in the hospital dating back as early as 2015 of issues with patient care?
Objection to predicate foundation. Check your approach.
Approach.
Villaray, did you email me so I could just email you the link right back? I'm going to put my email back up. Can you email me real quick? And so I could email you the link and then you'll have it right on your computer. I can't find it. Donna, can you drop it in the chat one more time? I'm sorry. Oh, here, Patroness Code is on it. Thank you, honey.
Are there any other questions?
No, Your Honor.
Members of the jury, any other questions from the jury? May this witness be excused.
Yes, Your Honor.
Yes, Your Honor.
Thank you, sir. Thank you for being here.
Nothing from the jury. What say you about that, you guys? Jury had no questions for this witness. I think that's interesting. What do you think? That's crazy. Okay, Villaray's going to email me and we're going to get her on here. We're going to hear what she has to say. Think of some questions for her. Or him. I'm not sure it's a her. Thank you, Denise, for thanking me. Thank you for thanking me for covering this trial today. Thank you so much for your super chat. I appreciate you. Hey, Jason Betts. Thank you for your super chat. Frank Langella as Hunter. Oh, yeah, that's a good one. Is he even still alive? I'm not really sure. Hi, Lori. I feel like he's talking in circles. Yeah, word salad. Word salad. Biggest gorgonzola salad I've seen in quite some time. Thank you for your super chat. Appreciate you. AJ McCleary, thank you so much for thanking me. Thank you for your very generous super chat. I appreciate you. Oh, Sarah, thank you. What do you feel obligated for? Don't be silly. Thank you for your super chat. Hey, Matt Bond, thank you for your super chat. I can help design merch if you need. I was a something tech and photographer, musician, a tech and photographer before my CRPS got bad. You should see my tailor collection. Oh, I would love to. Yeah, didn't you send me a message on Instagram? That'd be great. I need some help because the I am not a cupcake stuff that I designed, don't order it just now because I got to fix that logo because you can't read it. It's hard to read. So I'm not going to recommend that right now. The other stuff is good. The come for me in the comments stuff is good. The Team Maya stuff is good. The other one, the logo is not really readable. It's too small. My name is too small. Hi Beach Lover. Thank you again for another super chat. I'm from Florida Panhandle. No, we don't say that about the 3 billy goats and a maggot. Thanks again, Beach Lover. You just can't stop giving, can you? Love me some Whitney. Yeah. Thank you for your service in the Navy. We love that. Hey, Cat Lady, thank you for your super chat. Do you think the jury grasped the full weight of the IJ info testified about today? I do. What say you? You guys think so? Do you guys think so? All right, Villeray, I'm not getting the email from you, so I'm going to drop it. I'm going to drop the stream in the chat for Villeray only. Villeray, just link on that. Just click on the link and you can come in. I do think that they grasped the full weight. Yes, everyone says yes. Yeah, let's get the likes up, you guys. There's still like 1,200 people, 1,189 people so far. Patroness Glow is one of the coolest usernames I've seen in a long time. All right. Villeray, if you're going to come in, come on in. When I see you on the screen, I'll put you up and you can talk to us. Kez Chick 56, thank you for becoming a member. That's amazing. We could do jury. We've already been here for like 3.5 hours, guys. I don't know if you want to go over jury instructions. They're pretty long. You can watch them yourself, and there's really not a lot that I can add to them. I mean, they are what they are. There's not a lot of commentary. I don't want you guys to think that I find this subject of this trial or CRPS in any way, shape, or form funny. It's just that sometimes if we don't laugh, we're gonna cry. So we got to some nights we got to keep it light. We do a lot of heavy topics in here, a lot of heavy topics, and a lot of true crime, and a lot of death, and a lot of stuff like that. So you know, it's not that I think the subject is funny, but sometimes we just have to. Otherwise, we're just gonna cry all the time. No, Cheryl, the trial's not over yet. They're going to do closing arguments tomorrow. Yeah, jury instructions are good. And I do suggest that you go back and watch them. And they're about 1.5 hours long, but they are going to give you the roadmap that the jury has to follow to come to their verdict. So you're going to hear everything that they're going to have to decide and when they're allowed to award punitive damages. And they're very interesting. If you want to listen to them, to put yourself in the seat of a juror. So I do suggest that you do listen to them, but I think for me to go over them with you would just be kind of boring. I mean, I think the stuff that we did today was the most lively of the day. Please do sanctions. Beach lover, you're just loving me today. What do you want me to say? Sanctions is money. It's a fine. It's a pay up. It's a punishment. So in the motion that they made for sanctions today, which was, I don't forget how many pages we said it was. Where is it? It's right here. It's like 327 pages. I can just put it up here on the screen real fast. But I mean, the best way to hurt an attorney is to make them pay money. So they can pay the costs for taking that deposition over the weekend. And then they can also be sanctioned for not turning over the discovery that they should have turned over earlier. And for not acting in good faith. And it could be $5,000, $10,000, $50,000. It could be a lot of money. It could be, you know, the judge could take it upon himself, at least in New York, to refer the attorney to the grievance committee, which is the overseer of bar licenses. And it's not a place you want to ever have to go or be. Is the grievance committee. You don't ever want to have to be defending yourself in front of the grievance committee, because that's who determines whether or not you are disbarred or suspended or censured publicly. Almost like a public flogging in print in the New York Law Journal. You don't want that. So depending on whether he thinks it's how egregious he thinks it is, it could be a problem for these guys. You know, I don't know, but we saw when we went over the dependency court order after Beata passed, when the judge in the dependency court released Maya to her father's custody, the hospital still fought her release, still fought it. Hunter and Shapiro were the attorneys for the hospital in the courtroom that day. So the roots run deep, you guys. The roots run deep. I never hope that any lawyer gets in trouble. I think it's a horrible place to be, but you know, we have codes of ethics for a reason and they're not to be taken lightly. And I'm not saying anybody did anything wrong, but if you just wanted a definition of sanctions, that's what it is. Speak Life, Garden, Homestead, and Permaculture. Melanie, do you think judge's history with the defense is affecting his treatment measure of discipline of them? You think defense is pushing boundaries, deliberately taking advantage of this relationship? No. This judge is not going to lose his seat over this defense firm, because trust me, it's a small pond, right? You see these same attorneys all the time. So I don't think so. I don't think he would ever jeopardize his seat on the bench for any attorney. No, I just don't see it. You can disagree with me. Come for me in the comments. Yeah, no, I don't think that they did wrong, but I don't think that the judge would risk his position for them. No, I don't think so. I mean, listen, we've seen what public corruption looks like right here in Suffolk County, New York. Right here in Suffolk County, New York, where the Long Island serial was not killed. The Long Island serial killer was not caught for 13 years because of the deep corruption in Suffolk County. From the district attorney, who is now in jail, to the chief of police, who just got out of jail, the corruption in Suffolk County runs deep. In Sarasota County, I don't think we're not at that level here, and I don't think this judge would risk it. Oh, Villa emailed me. Okay, hi Villa Ray. Okay, got it. Thank you. I know it's so hard to get my attention when I get talking and crazy. And all right, let's see. Invite. Okay, I just emailed you back. So just click on that link and then you can come in. You just need like a microphone or something. If you guys want to get your questions ready. I got lots of questions. I want to know if the jury's paying attention. I want to know if anybody cried. I want to know if what they were thinking about today, or because they had no questions. Were they on the edge of their seat when they saw this testimony of Corcoran today? Because they might have been a little bit annoyed because they had like almost the whole day off, except for the hour and a half they sat through jury instructions. So this was in the morning, but I think they went to lunch at like 10:40 in the morning. They had an early lunch today, right? I think it was early. But if I was retired, I would go sit in the courthouse every day. I do. I follow Rex Yerman around like a puppy, like, hello. And then that day when he looked at me in court, he looked me right in the eye and I freaked out. That was freaky, you guys. You ever been in the same room as a serial killer? You ever have a accused serial killer, innocent until proven guilty? Ever have an accused serial killer look you right in the eye? It's chilling. Yeah, you can. Victorine, go down to the courthouse. You can spend the entire day just walking around from courthouse to courthouse. I mean, courtroom to courtroom. It's open to the public. Doesn't even have to be like a famous trial. Yeah, he looked me in the eye. Hi, Villaray. I'm going to put you on. Can you hear me?
Hi, I can hear you.
Oh, hang on. Hold on.
Right.
Let's put you in.
Okay.
Dun, dun, dun. How do I change the layout? It says audio only. Wait. All right, you're in with audio only, but I can't change the layout. So can you guys hear her?
Hi. Hello.
Can you guys see her? Wait.
Oh, no camera.
No, I mean, can you hear her? All right, say something.
Hello. So happy to be here.
So happy that you came in. So happy that you came in. I don't know. Oh, they can hear you. We just can't put you up as just like a little figurine. I don't know. I'm trying to get you up here like a little figurine, but it's not working.
Oh, I'm not worried about it.
Oh, so tell me. So have you been going to this trial every day since the beginning?
I wish. I live a couple of hours away, and I do have CRPS, and it was tough, but I did it. I wanted to do it for the anniversary today. Today's the 10-year anniversary of paint the world orange. And anyway, me and my family, there was 4 of us that went today, and we sat in the back and we just supported, was there to support. So yeah, it was
That
good.
is so amazing. I had orange on yesterday because somebody told me to wear orange. So I did my orange wearing yesterday on last night's stream. They're saying, "Hi, Villeray, you look lovely." Are you in front of a computer so you can see the comments?
I can see them. I can see
Oh,
them.
okay.
That's
Yeah, if I
sweet.
highlight them, like you can see them.
I'm seeing what you're putting up on the screen. Yeah,
Yeah, there's a little bit of a delay. So if you're watching it on YouTube instead of StreamYard, it's like weird. It's like a weird delay. So that's
okay.
really cool. So you went with 4 family members, and today was the first day that you got to go there. Was there
Right.
a long line to get in, or was it crowded, or how did that work?
It,
Did you need a
it
ticket?
was a pretty big. I mean, it was pretty full today, which I was happy to see. I really was. And during the first 5-minute break that we got, as Maya was walking out, one of my kiddos that was with me, who also has CRPS, um, went over to say hello. And Maya was so gracious, so kind, just so nice. And,
Oh,
took the time, and I'm like, we got to let her go. She's only got a few minutes. So anyway, she really was. She was super, super sweet.
how old is
And
your child? Is it a boy or girl?
it's a boy, and he's 21. I know he's a little
Oh,
bit older, but anyway,
that's
yeah.
so nice. And she was kind to him. Oh, that's
Yes,
amazing.
she really was. She was really, really sweet. And yeah, I mean, just big smiles, and just, yeah, she was happy to see us there, I think. I mean, we certainly colored up that side of the courtroom, that's for sure.
You guys are warriors, all of you. Somebody's asking,
Yeah.
Fallstar says, when His Honor was reaming out Hunter, what were the vibes in the courtroom?
Oh, I think everybody was just like, yeah, he had it coming. Yeah, I mean, he really did. Yeah, I mean, it was just, I don't know. I mean, they have to win this. That's all I
Yeah,
know.
well,
They have to win this.
I know.
They are deserving of it. And I really believe that, Maya's so darn smart that I believe she'll go on to do good things with it, you know.
I do too. I
So
do too. What, so
um
did you look at the jury at all? And what was the jury's reaction to some of the stuff that went on there today?
they didn't have a lot of reaction to me. I mean, they all seemed very engaged, very focused on what was going on in the courtroom, that sort of thing. But yeah, I mean, they just were very engaged. I did leave at around 2 o'clock. It was an early morning. Had to get up and get out of here at, like, I don't know, I think it was 5:30 or something crazy like that. And still didn't get on there on time, which annoyed
Oh,
me. But
really?
anyway, just traffic and whatnot. And anyway, it was a hike to get there, but I really wanted to do it. My family was very supportive and went with me, so it was great. It was great to be there and just feel like we were doing some kind of good. But I tell you, Shapiro's a really tall man. And he did something today to Jules that I just thought was so tacky. He said to her, so what are you going to do when this is all over? Get a life? And and I was like, wow, I can't believe. And she threw it right back at him. She was like, what are you going to do, go on vacation finally? So
God, I can't believe, where did he say that to her? Were they in the hallway? Where did this
she had
exchange
just,
happen?
yeah, just on a break as they were getting ready to leave, I think. And anyway, it was just tacky. I couldn't even believe he said it. Jules had actually, if I'm being totally honest, Jules had called in on Recovery Addicts
No, yeah, we
line
know.
with
Yeah,
that information, and I was just like, you are kidding me. Um,
really rude.
just such a jerk. I was like, wow.
Really rude.
Um,
Well,
but anyway,
somebody, go ahead.
no, I didn't mean to cut you off.
Oh, no, that's okay. Keep going.
Yeah, so it was good to be there. The doctor that testified today was sitting right in front of me. He's a very nice man as well. He and Joel sat together during most of his time there. You know, the poor man had a procedure scheduled today, and
Oh, we thought he had a doctor's appointment. Yeah, I didn't know it was a procedure.
yeah, and he was like, "Well, let me see if I can get him to move my procedure so I can continue to stay here and wait to get on the stand." And he did. I mean, it was just pretty incredible that he did that, and they needed him. So
Yeah.
that was really great.
He's very kind. You see, we've been watching him. We've decided that, let's see who won the poll. We decided that George Clooney is going to play him in the miniseries. He won the
Oh,
poll. With
fantastic!
Richard Gere coming in second at 32%. George Clooney at 44%. John Hamm only got 14%. I don't know. I was thinking John Hamm. And then John Stamos in there with a little 10%. But
You and I have
um,
something in common. We both
what's
like
that?
film, and I used to have my own video production company for about a decade,
Oh,
and
really?
yeah, yeah. So this is fun for me to see you do these polls and such. It's fun.
Oh, that's fun. Yeah, I'm a big fan of television and all that kind of stuff. I'm very interested. I watch a lot of TV. What was the jury like when Dr. Corcoran was on the stand?
You know, everybody was very in tune to him. I mean, it got quiet, and they were very much paying attention to what he had to say. You know, he's so articulate, and just you know, versus I can't even remember what the um, oh gosh, the executive's name that came on the stand that was his counter. What
Oh,
was
Dr. Mark Anderson,
right?
the one who we thought was going to have a
That's
heart
right.
attack.
Yes,
Yeah.
yes, Anderson. Witness Anderson, I guess is what they're calling him. And
Mhm.
yeah, I mean, you put those two up against each other, and there's just no competition there. I mean, there's
Right.
just not. The man doesn't even seem fit for the role, in my opinion, compared to the gentleman who testified today. Um, so yeah, no, everybody was very attentive, and um, anyway, yeah, it was good to have him there. I'm glad that he stayed.
Yeah, I know. I know. I mean, you can tell how passionate he is about this case and how much he believes in it and how he's really out there to do some good and just change, what's going on in hospitals, and hopefully it'll help hospitals revamp their policies and procedures so something like this never happens again. I mean,
Right,
it's like a
right,
mission for him, I think.
right. And you know, there's a lot of change that needs to happen. There really is. It's it, I'm 20 years with CRPS, and it's I've seen so much, and yet I thought we had made a lot more progress than we've really made. Watching all the testimony over, you know, what, several weeks now, it just proves to me that we've got a long way to go in educating the ones who are educated. Do you know
Mhm.
what I'm saying? And
Yeah, the
it's
doctors, you think, you go into
right.
the hospital, like they're gonna know when you say you have CRPS. We didn't know. We didn't know that.
Well,
That
the ones
doctors
who
didn't even know
really
about it.
scare me are the ones who pretend they know. You know what
Yeah.
I'm saying?
Yeah.
They act like they know what you're talking about, and it takes me about 5 seconds to figure out that they don't. But
Mm.
you know, but they're the ones who are dangerous. It's you know, especially to someone new with CRPS.
Yeah. And medical
And
gaslighting is a real thing, right?
oh yeah, oh yeah. And you know, the doctors who have been at the game for a long time and are confident in themselves, you know, they're the ones who are probably more likely to help you. You know,
Right.
they're
I
not
did a show the other
intimidated.
night. Yeah, I did a show the other night with Dr. Kave on who has a channel called Medical Secrets. Do you know him? And he did a whole video about medical gaslighting and CRPS and the Maya trial. So I had him on my show the other night and we did a great live with him, and everyone asked him questions and he had some really great tips for patients who go in to see doctors when they're being gaslit, and what to do
Right,
and how to, make the most of your doctor's appointment. And he's a great guy. Um,
right.
Another question for you, from Dehydrated Slime says, Villa Ray, do you happen to know which juror number the juror that was dismissed was? I'm talking about the numbers that Jules assigned to them.
I think Jules said that it was her juror number 7, I want to say, is what
7?
she's, yeah, is the juror number 1 for her. I believe that's what she said.
Okay.
I believe
That
that's
was
what she
interesting
said.
because those of us that were watching it on TV, you were live, so I don't know what you thought was about to happen, but we thought he was about to excuse the juror that was the subject of the motion.
Right.
So
And
confused.
I was listening to it on the way home because I actually, like I said, I had to leave at about 2 o'clock to start making my way back home. But um, yeah, no, it's yeah. Anyway, um,
Well, it sounds like you had a long day and you're probably really
I
tired.
did. I'm sorry. That's part of the
No, but I
problem.
thank you so much for
I'm
calling
on
in.
medicine and no sleep, but I'm
I
sure enjoying
well,
your show. I really am, and
oh,
I
thank you
appreciate you
for
having me
watching.
on. And had I known, I'd have taken better notes. I'd have.
Oh
Anyway, I
no, we
appreciate it very much.
just like the eyes and ears. And is Dr. Quirk okay? Is the judge as kind as we think he is? Because I feel like
Oh
every
my
time the judge
gosh,
gets
yes.
upset, he's like, "Oh, okay, I need to take 5 minutes," and he just leaves and he goes and he does yoga or meditation or something. I don't know. He
Right,
has a chai
right.
latte. I don't know what he has, but it seems like do you think it's because of the cameras being there, or do you think he's
I think
genuinely
I
nice?
get a vibe that he's genuine. I really do. I just do. I think he's really a nice man. Who frankly I think he feels for this situation. That's what
Yeah,
I'm getting out of it. But doesn't want to seem partial or whatever. But it I don't know. I don't know how you could listen to all this and not feel that way. And
right.
especially with the nuclear bomb that was dropped on Friday or no, what was it? Wednesday last week.
The
Um,
day with the IJ reports and the Joint
right,
Commission reports. Yeah,
right. So,
yeah.
yeah.
So tomorrow, I think is supposed to be closing arguments.
I
So
know. I wanted to be there for closing arguments, and there's just no way I can do 2 days in a row of that. The seats are horrible. I mean, for somebody like myself, it's hard to do. But dang, I wanted to be there for closing arguments, and but oh well, it's okay. I felt really good that we were there for the 10th anniversary for today for CRPS, and
well,
just
we're so happy
try to
that you were there
support.
too, and we're trying to raise awareness here, and that's what we're trying to do. And I think a
God
lot of
love you,
people.
Melanie. God
Oh, you're
love
so
you. Thank you.
have you been watching
No,
with
it's
us?
important, and I've been watching you.
Oh,
I've been
good.
watching you. Yeah, and it's the awareness is so needed. I mean, it really is. Orphan conditions just don't get enough exposure.
I know.
And it irritates me so bad to when they were bringing up pictures of Maya and showing her off, I don't know, what was it, homecoming or something recently she
Yep.
went to, and I thought, wow, you're gonna, you've already intruded on her in so many ways, and now you're gonna step on this. Nobody knows what she went through to
No.
get out that night or what she did. If you just look at me, there's no way you'd know anything's wrong with me. Really.
Right.
I mean,
Because yeah, people that are in chronic pain don't tell people they're in chronic pain because they think people just don't want to hear it anymore. So you try and hide it, right?
well, somewhat, and then, we quit talking about it because, "Oh, yeah, I broke my finger, I know exactly what you're feeling," and it's like, okay.
Mhm.
Sure you do,"
Exactly.
you know?
Would you do me a
So
favor since you have my email now? Would you pick
sure.
out some merch for you and your son and send me what a shirt or a hat that you guys want
Oh,
each
no way.
and your sizes and I'll send it to you
Oh
as
my
a gift?
gosh, you're too much. Thank you
Oh,
so
well,
much.
thank you. Well, thank you. Wait, I think you said that you were not there when juror 181 was dismissed, right?
I wasn't, and like I
Okay.
said, I had to
Somebody
cut
had a
out a little
question
bit
on that.
earlier. I'm sorry. I'm
No, that's
sorry.
okay. Somebody just
I'd
had
have
a
been a
question, but
better reporter had I known.
oh no, not at all. Not at all. But we love boots on the ground. Boots on the ground are great.
They
I
are.
don't think the jury was in the room. In fact, I think this happened after the jury left for the day. You guys, whoever asked me this question. So I think that's what
I think you might
happened.
be right.
Yeah, because I think he did it after he excused the jury. He said, you can all leave now except for juror number
He did.
181.
That's exactly what happened.
Right.
Yes, that's exactly what happened.
And that's why I thought that motion to dismiss the juror was going to be denied, because he let them all go in case he wanted to question that other juror. He wasn't there anymore. So
Right.
everyone is thanking you for calling in
Oh,
and for
well,
supporting.
I was nervous. I'm behind the camera kind of person. I'm not,
Oh, right.
not on the microphone. I'm not in front.
You're not on air talent. You like being behind it?
No,
I could use some technical help. Oh, too bad you live in Florida.
Well, call me. I'll send you my number. If you need anything, you give me a call. My
I
husband's a
will.
programmer, and yeah, we know our way around some technical stuff. So
Excellent.
yeah.
Did you do the bulk of your work in New York or LA or?
No, in Denver actually.
Oh,
Yeah.
I went to Boulder. I went to
I
CU.
know. I saw that. I was like, woo, look at her.
And I went to law school at DU. I didn't want to leave. That's I wanted to stay in Boulder. I was like, what can I do to
Yeah,
stay in Boulder? Oh, I guess I'll apply to law school. And that's what I
right.
did. And I stayed out there for a long time.
Yeah, I lived out there for about 30 years. I absolutely loved it. And but to get out of the winters and the cold was just, I'm getting to an age where that was what I needed to do. So
Yeah.
anyway, so we're in Florida now, and we're making it our home. But
Oh, that's
yeah,
great.
yeah, we were there for 30 years, and yeah, I had a production company there, and we did all kinds of things, all kinds of work. So,
Oh, that's
yeah.
amazing. Everyone is saying thank you. All right, I think I'm going
Oh,
to sign off. Don't forget to send
all
me, pick
right.
out the merch that you want with the sizes. And thank you so much for calling in. And I love
Thank
that
you
you're
so much
watching,
for
and
having me. I
stay
appreciate
strong,
it.
and Team Maya
Thank you
all the
for
way.
covering it, Melanie. Thank you so much.
Oh,
Appreciate
my
you.
pleasure. Thank
All
you,
right.
hon. All
Take
right,
care. Have
sweetie.
a nice
All right.
one. Bye-bye.
Bye-bye. All right, you guys, that was pretty cool, huh? Okay, I think we're into this for almost 4 hours. I'm going to say goodnight. Love you guys. Thank you to my moderators for sticking in there. It was like a marathon tonight. I appreciate you so much. To all of my viewers, my replay viewers, my channel members, my children, for putting up with the fact that they are not allowed to knock on my door while I'm in here for 4 hours every night or day. And if you guys wouldn't mind just hitting the like button on your way out, it's free to subscribe. Just subscribe, hit the like button. It helps the video get pushed out there so that more people see it, because this is really, really a really important case. And we really need to spread awareness. We need to talk about the hard stuff, CRPS and all other chronic pain diseases that are hard to diagnose and hard to treat and have no cure, to the DCF system that is privatized, that will take away your parental rights within 2 days on a false accusation of Munchausen's and strip you of your parental rights. It's a very, very frightening prospect. So thank you guys for hanging in. 1,000 people for 4 hours. I am flattered and amazed. I will come back tomorrow and do a recap for you of closing statements, closing arguments. And hopefully they can get that done in the morning, and they'll be done in the afternoon, so that I can come to you maybe in the afternoon with that. So if you subscribe and hit the bell, you will know when the next stream is going to happen, and you will never miss a beat. George Clooney did win the last poll. So tomorrow night we'll cast the rest of the miniseries that we are casting. Thank you guys. I'll see you real soon. Don't forget, be cool, be kind, be classy. Peace.